Benching ko na nga na naka-online na participants. So. Maratab talaga.
Do you know that procurement is crucial in achieving our society's collective vision of a strongly rooted, comfortable, and secure life in the Philippines? Hello everyone, I'm Billy Bayong. Let me show you how our Procurement Policy Board innovates, adapts, and responds to our changing needs to enhance the procurement system and help the government work for us. An efficient, transparent, and competitive procurement system connects every Filipino to vital services from the government. This can help move more people out of poverty, gain access to better education, receive quality healthcare, and enjoy economic opportunities. These yield greater trust in government institutions and bring the country closer to achieving its national development goals. The Government Procurement Policy Board focuses on simplifying various processes to produce more successful procurement that contributes to the effectiveness and efficiency of the government. The board employs strategies to identify needs and implement projects. It refines and calibrates procurement policies, adjusting to emerging trends based on needs of procuring entities. It creates ways to capacitate practitioners to better manage their procurement processes, monitor effectiveness of our procurement systems, and it adapts to the times, especially during national emergencies. The GPPB has strengthened the procurement process at the earliest stage, the planning phase. The board has issued bidding rules responsive to new laws and policies set by the government. GPPB has also streamlined the bidding process through the use of technology. GPPB has introduced guidelines to ensure timely procurement, especially during a national emergency. GPPB Technical Support Office pioneered initiatives to better assist procuring entities. Simple and competitive, transparent and accountable, monitored by the people. These make for an effective procurement system, responsive to the needs of the people. The GPPB, adapting, responding, innovating for nation building. To know more about procurement, visit gppb.gov.ph.
The Philippines is going to buy green. Our government is taking the lead. The Philippines Green Public Procurement Roadmap guides the way forward by considering local business capacities, climate, environment, health, and value for money. Our government procures thousands of items every year to serve the Filipino people. When government is the single largest buyer in a market, its procurement decisions influence the direction that businesses take. Green public procurement is about buying products which are low carbon, are healthier, avoid harmful chemicals, and are manufactured through cleaner processes. They are efficient to use and consume less energy and water. At the end of life, precious materials are recycled. GPP reduces the pressure on the environment. GPP is a partnership between the government and businesses. GPP opens up new, exciting, and reliable opportunities for businesses supplying green products. This in turn makes green products also affordable for private households. A first batch of 20 product categories has been prioritized for GPP, and more will be selected over time. The supplies and equipment products are multi-copy paper, toilet paper, record books, cleaners, chairs, disinfectant sprays, trash bags, liquid hand soap, detergent powder, and LED lights and bulbs. The priority non-common supplies and equipment products are computer and laptop monitors, air conditioners, vehicles, fridges and freezers, copiers, paints and varnishes, food and catering services, training hotels and facilities, toilets and urinals, and textiles such as uniforms and work clothes. The well-established public procurement processes in the Philippines, such as the PhilJobs, will ensure fairness, transparency, and open competition for the green venture. Everyone can become an active consumer of green products, which save energy and water, are not harmful for health and climate, and which are recyclable.
All right. An extravaganza morning, and thank God, oh my God, it's Friday. Welcome to the third batch of the online training on Government Procurement Reform Act, or the Republic Act 9184 and its 2016 revised implementing rules and regulations for the municipal local government units, brought to you by none other than the Government Procurement Policy Board Technical Support Office. And for the last time, I am Marky Duetes from the Capacity Development Division, still slaying on the last day of our event. All right. To start our today's program, may I request everyone to put ourselves in the most mighty and holy presence of Lord Jesus Christ. Loving Heavenly Father, we come to you this hour asking for your blessing and help us as we gather together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of joy and enthusiasm. Give us the desire to find ways to excel in our work and help us to work together and encourage each other to excellence. We ask that we would challenge each other to reach higher and farther to the best we can be. We ask this in the name of our Lord Jesus Christ. Amen. Once again, a blessed Friday morning to everyone. All right, now at this point, before we shift to the lecture proper, as promised, let us first award the last early birds winners of our activity. Starting with Miss Jasmine C. Pasumbal from Municipality of Mauban, Quezon. Congratulations po. Our next early bird winner. Grabe yung delay ng clap natin, no? Alright, for our next winner, we have Miss Jessa Angelica Milon from Municipality of Mauban, Quezon. So, araw po ng Mauban, Quezon for today. Alright, again to our early birds participants, congratulations po. And please check your Zoom chat box or your email, as our event secretariat will coordinate with you on how you may claim your special tokens from GPPB PSO. And also for the rest of the winners of our trainees starting day 1 na hindi pa po nakakapag-provide ng kanilang shipment details, kindly direct message our event secretariat or check your emails po so that we can have your shipment details. Sayang naman po yung special tokens. Diba? Alright, for our morning activity today, we're going to play word hunt. This is essentially the same as word hunt puzzle na nakikita natin sa mga newspaper or any means na we encounter this kind of puzzle. But this time, we're going to play it virtually. So, I think we're stuck on the slides of yon siya. So you need guys to exert effort using your magnifying eyes looking for me. No, no, not me pala. For the words we specifically looking per category. So again, you're going to answer in our Zoom chat box as many as you can see in just one message. Alright, one message lang para madedetermine natin kung gaano karami ang magiging entry ninyo per category. Kasi kung paisa-isa kayo, matatabunan yung mauna yung entry, o wala na rin. Hindi rin natin malalaman kung ilan ang entry po ninyo. Alright, so again guys, be ready and get focused. Focus lang sa goals. And if you can see anything aside from letters, just look at you now, look at me. How you like that? Diba? Joke lang. I'm just setting the perfect mood or ambience for this lovely Friday morning. Okay, now let's start. Spot the tourist spots. Ayan, yan ang ating activity for today. So we're going to look for look for those tourist spots in our puzzle. Then you're going to type in nga in our Zoom chat box. All right. We have category Luzon, Visayas, Mindanao. So, obviously, when our category is Luzon, we're just talking about tourist spots na matatagpuan po sa Luzon. Okay, let's start with our first categories. Ayan, five tourist spots located in Luzon. I'm giving you 30 seconds to look muna. Please wait my signal go bago nyo po i-type. I-jot down nyo po muna yung papers yung makikita nyo. Alright, let's start the countdown. Okay, ayan, 25 seconds left. 20, 15, 10, and 5, 4, 3, 2, and 1. Now, please type po kung ano po yung mga tourist spots na nakita ninyo sa ating puzzle. Merong dalawa, may entry from LG Bataraza, Intramuros, Mines View, Mayon. Dalawa lang, tatlo, may tatlo, si LG Bataraza din, Mines View, Intramuros, Rizal Park. Wala na bang lalagpas sa tatlo? Meron si MLGU Mauban. Si Miss Shaira Pastrana, ang kanyang pong entries ay Mines View, Anawangi, Intramuros, Mayon. 4. So far, si Ma'am Shaira po ang may pinakamaraming entries para po sa ating first category. Meron siyang nakitang 4. Last na po, we're going to end our first category in 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. We have here Ma'am Maria Leia, Mines View, Intramuros, Rizal Park, Mayon, Anawangi, 5. Right? For the result, ano po ba mga tourist spots na meron sa ating puzzle? Ito po ay ang Rizal Park, Intramuros, Mayon, Mines View, Anawangi. Alright, congratulations Ma'am Maria Leia. Nakuha mo po ang 5 out of 5 sa ating puzzle. Diba? Matalas ang mata, ang paningin ni Ma'am Leia. Magaling maghanap. Alright, for our next category po, find 5 tourist spots located in Visayas. Visayas naman this time. Go, 30 minutes. 30 seconds po muna tayong maghahanap. Yan. Hanapin muna po natin. $20 seconds left. Ayun na, may nakikita agad ako. Alright, 10 seconds left. And 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. Now start typing your entries for our second puzzle. Ang bilis naman ni LGU kalapit. 1, 2, 3, 4. Apat ang entry. Oslo, tayo magdapalaw. 1, 2, 1, 2, 3, 4. Mindoro, Bantayan. 1, 2, 3, 4, 5. Alright. Ang galing naman maghanap. Ayan, sana all nahanap. Alright. We're going to end our category number 2 in 5, 4, 3, 2, and 1. Ano po ba ang mga tourist spots na makikita sa ating puzzle? We have Panglao, Mactan, Bantayan, Boracay, Oslo. Ayan. Also Mindoro. Mindoro is a lugar. Baka na-type lang natin siya. Pero anyway, consider na natin siya. Maganda rin naman ang Mindoro. Maganda ang Mindoro. Let's clarify that. All right. Congratulations po sa mga nakakuha ng ating nakakita ng ating tourist spots for our category number 2. Now, for our third puzzle, find 5 tourist spots located in Mindanao. 30 seconds starts. Hanap muna tayo. Yan. 20 seconds left. And 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. Then go! Type your answers or your entries in our Zoom chat box. Wala pong nagtatay. Wala po silang makita letters. Ayun. Isa lang. Meron pa yan. Sige, hanapin nyo lang. Lake Cebu. Maganda dyan. Puntahan natin. Lake Cebu lang ba? Hindi ako naniniwala. Lake Cebu lang ang nakita ninyo. Meron pa yan, guys. Ayun o. Ayun o, tinuturo ko. Aliwagwag. Mukhang nahirapan po pa kayo for our third category. Ayun o, ito yung isa sa pinakamagandang beach na napuntahan ko yung Mindanao. Promise. Yung isa. Share ko sa inyo yung pictures ko doon. Joke lang. Joke lang po. Bakit hindi nyo nakikita yung nakikita ko? Naiiyak ako. Joke lang. Ayan, 3. Dahican, Lake Cebu, Aliwagwag. Alam, hindi nyo pa rin talaga nakikita yung yung beach sa Mindanao sa may... Pag nagbigay kasi ako ng lugar, maano nyo yung clue eh. Malalaman nyo yun. Pero maganda dito, nasa middle part, ang tagalan natin. Hindi ako titigil agad din yung nakikita yung magandang beach sa Mindanao na napuntahan ko. O baka hindi na tayo matapos sa activity to dahil wala talaga nakakita. Alright, we're going to end our third category in 5, 4, 3, 2, and 1. Ayan, nakita ni Maria Lea yung magandang beach na sinasabi ko. Alright. Malamawi. Oh my God, guys, check that beach. Napakaganda dyan. Punta tayong lahat. Alright, Malamawi, Lake Cebu, Dahican, Tinago Falls, and also Aliwagwag. Alright. So, as we end our activities today, I hope you're now going to schedule your trip to any of the tourist spots in the Philippines. O, diba? Actually, from paid partnership po tayo ng Department of Tourism. Joke lang. Alright, I hope that we already enabled. And, oh, by the way, that ends po our activity for our last day. Ay po pala. Ito po yung kung saan siya makikita. Ayan. All right, again, thank you guys. And that ends our morning activity. I hope that we already enables, activate, and fuel our mental cognizance this morning, and now ready for our learning session. Ayan. Moving on, just a quick recap lang of our yesterday's learning session. We had an entire session on alternative methods of procurement where we had an extensive discussion on the various alternative methods which may be utilized in government undertakings and its appropriate use based on the prescribed conditions, procedures, and documentary requirements. Led by our yesterday's resource speaker, the one and only Director Renato De Vera. All right, for today's activity, I am particularly thrilled because we will be tackling about penal, civil, and administrative provisions for our learning session number 6, and will be followed by our last session discussing, baliktad po pala. For our first session this morning, we're going to tackle protest mechanism and blacklisting guidelines, and will be followed our last session for this training, which is the penal, civil, and administrative provision. All right, so please do ready your A game as we're going to our final stretch of our learning activity. With that, allow me to introduce our research speaker for our today's session. Our resource speakers graduated at University of Southern Philippines Foundation with Bachelor of Laws, and she finished her master's in public policy at Tokyo, Japan. She is currently attorney for the legal unit, Office of the Regional Director of the Department of Interior and Local Government, Regional Office 7. Joining us today, the attorney for of the Department of Interior and Local Government Regional Office 7 and a GPPB recognized speaker. Please welcome Attorney Isa Piel Nogra.
Good morning. I can't see myself. Can you hear me? Good morning, everybody.
Good morning, ma'am.
Yes. Okay. Welcome to the last day of your activity. Should I say that again? I was surprised, that the topic on protest mechanism comes first before the penal, civil, and administrative liabilities, because usually it's the other way around. I had to change immediately the slides I'm preparing for myself too. Anyway, I'm glad you all have the energy to finish all of this, and hopefully, I'm sorry if I wasn't able to provide, like your previous speakers, pre-recorded lectures because of some personal health emergency on my part. Anyway, just bear also with the sound, whatever you will hear around me, because I'm in my home recovering. So we can start already. I'm just waiting for the slides of Ms. Chanel. So we will start with protest mechanisms. Obviously, are we having a problem with the screen sharing? Okay pa naman ako?
Yes, ma'am. Okay po.
Okay. So it's the start. Akala ko ako yung nag-loading kasi na ganun-ganun pa yung sa screen sharing ni Ms. Janet. Naglo-loading pa yung screen sharing, no?
Actually,
so basically, really? Oh, wait. Maybe because at the same time, I've been downloading already the materials for the penal, civil, and administrative liabilities when I realized there's a change in the topic that the protest mechanism will go first. So I had to open again the slides, and I think it affected because I've been downloading now also. So anyway, we will just start on protest mechanisms. So the outline for our topic would be protest mechanisms. and requisites for filing of valid protest and procedures and resolution of protest, and blacklisting guidelines. No, so the blacklisting guidelines procedure include those which happens during procurement stage and during contract implementation stage. Also, we will discuss the online blacklisting portal. So if you see, the protest mechanism and blacklisting guidelines is a necessary consequence in the bidding procedures because there are uniform standards in bidding procedures and goods, infrastructures, and consulting services, and there are also um, mechanisms provided by the law to make sure that all the and will be followed. No, the procedures will be followed. Is the audio okay there? I'm concerned with the audio. Okay, I just hope it's okay. So the protest mechanism is a mechanism that you the this is the mechanism that any aggrieved bidder or supplier will have to follow if they think that there is something that goes amiss in the back procedures, no? Or if there's anything that is considered not unlawful on the part of the other bidders also. Whereas in blacklisting, it should not be confused. Blacklisting is a process also to penalize either contractors or bidders who committed unlawful acts. No? So it should not be confused that it is the same procedure. Okay, protest mechanisms refers to any protest against the procedures observed during the bidding process, while blacklisting procedures is a proceeding for the any violation of bidders. So, to the host, may I ask if it's still okay? Because otherwise I will have to. Okay. Hello?
Hello, ma'am. Good morning po. Yes po, the screen is still okay po.
Pero hindi nawawala yung boses ko?
Hindi naman po, ma'am. So far, so good po.
Okay, kasi okay lang sa akin kahit hindi ko makita yung presentation as long as naririnig niyo ako. Okay, sundan niyo na lang ako ha. So we'll start with the protest on decisions of the bank. So ito pong protest on decisions of the bank, ito po yung mga protesta ng sino mang aggrieved bidder. Okay, when it comes to the decisions of the bank in certain bidding process. So the decisions of the bank bids the bank at any procurement stage may be questioned by filing of a request for reconsideration. So when you say protest, it is a two-stage proceeding. You have to any aggrieved bidder may have to file first a request for reconsideration before they can file their formal protest. No? So you cannot these aggrieved bidders cannot go directly to courts, or they cannot even go directly to the HOPE, your head of procuring entity, to complain about the process that you observe. Otherwise, they will be deemed as not any of their protest or court action will be dismissed for failure to exhaust administrative remedies. Why is it like that? No, the purpose. Sorry for that. My house is uphill. That's why you can hear it. Anyway, the purpose of our request for consideration is to give the Bids and Awards Committee a chance to correct any of its actions or decisions. No, you cannot just complain on a certain resolution because the back any decisions of the back is contained in a resolution to award, resolution to whatever. To award the contract. So if it's a resolution, then the action would be a reconsideration of the resolution. So it should be filed within 3 calendar days upon receipt of the written notice or upon verbal notification. So sino yung nag-agree feeling niya, hindi ako dapat ma-disqualify. Ako yung lowest uncalculated responsive bid. Bakit ako na po disqualify during post-qualification? So dun yung time niya na pwede siyang magreklamo. Or kaya may nakita siya na feeling niya, hindi naman, yung isang bidder, hindi naman totoo yung sinasubmit niya. Ganun. Pwede niya yung mag-submit siya with evidences na may mga mali sa sinasubmit ng bidder na nanalo or may mali sa determination ng bank o TWG assigned. So the back naman, within 7 calendar days from the receipt of the request for reconsideration, dapat nila yung gawa ng resolution, no? If they are to affirm, agree sila sa request for reconsideration ng aggrieved bidder, or they shall deny it and they will stand by their decision. So if the request for reconsideration naman is denied, the back shall forward it to the hope, no? The aggrieved bidder shall have the opportunity to forward it to the hope. It's the head of the procuring entity. And this time, that shall be the formal protest na. Okay. So why is it important to do this? No, it's important because the aggrieved bidder may have to have an avenue to complain, and if not, it will be the process itself will be subject to abuse. So yan po ang reason bakit may ganitong mechanism. From the level of the back, they are given a chance to reconsider their decision, and for the level of the hope, they are given also a chance to review the decision of the bank, because the hope is not part of the bank, and he relied on the bank whatever resolution that is issued by the bank. Diba? Sabi ng bank, our resolution is to award the contract to contractor A. Si Hope, he has the right to rely on that resolution. If there is no opportunity for protest, hindi niya malalaman kung may dapat bang i-correct or may mali ba na nangyayari during the procurement stage. So after yung 3 days to file a request for consideration, 7 days for the back to decide on the request for consideration, and another 7 days for the aggrieved party na hindi pa rin siya kontento sa decision ng back to raise the issue to the hope. And then the hope, ika-consider lamang niya yung protest if it is accompanied by a unrefundable protest fee. Meron na po tayong protest fee pag protest na siya na formal. Pag request for reconsideration pa lang, wala pa yan. Wala pang need magbayad. But pag formal protest na to the level of the hope, then there's already a requirement to pay a non-refundable protest fee, no? To be paid in cash. Hindi po pwede yung mga security like what we accept with bid security or performance security. Cash na po siya, ha? Hindi din check but cash. And also, the petition must be verified. It must be verified, and there's attachment of certification against forum shopping. Why is there a need to attach a certification against forum shopping? For the hope to make sure that there is no other action pending or being filed in another forum. Baka mamaya mag-spend pa siya ng time to doctor, yun pala may pina-file na special civil action, that's petition for certiorari with injunction at the court. So bakit pa niya i-waste ang time niya to resolve the protest when in fact it's already elevated to the court, no, prematurely. So yun yung requirement, bakit kailangan may attachment na certification against forum shopping. It should be addressed to the hope within 7 calendar days. Now, how about the verified position paper? Okay, yung verified position paper, ano po yung laman yan? Ito po siya. If you can see there, the sample that is given, it's just an ordinary document. It's just an ordinary document. That's not exactly the face of the verified position paper. Kasi po, makapal po yung verified position paper. Hindi naman po natin ilagay lahat per page, no? But it contains there the required statements. First, of course, the bidder's name and office address. Sino ang bidder na to? Baka kasi it is not the job of the bank or the hope to determine sino sa mga bidder na na-disqualify namin ang nagrereklamo. Yung bidder po na nagrereklamo should identify themselves. And also, they should identify the name of the project or contractors, because it could be that the bidder has 2 or 3 more bids, no, on different projects in a certain procuring entity, in a certain, for in your case, LGU. Baka mamaya marami siyang bid sa inyo sa iba-ibang projects. So dapat i-identify niya din anong project siya may complaint, meron siyang protest. Then, implementing office or procuring entity, to make sure naman kayo sa MLGU, alam nyo na kayo talaga yung inireklamo. Baka mamaya marami na din siyang mga bid sa iba na nirereklamo niya. May mga taong ganun, di ba, mahilig magreklamo. tapos lahat pinoprotest niya, yun. So, kailangan ma-identify din na yung actions nyo talaga, yung back nyo, ang inirereklamo nila. Then, brief statement of facts. Ano ang nangyari? Bakit, why you deem that the request for reconsideration, that that the resolution of the back that was request for reconsideration is not in accordance with law. Take note to act this on any consideration in accordance with the law. Nagmamakaawa. No, that's not enough ground to reverse your decision on who is the lowest calculated or responsive bid, or whether the bidder is actually disqualified really. So, hindi din nawa ka lang, sir, maawa kayo, sir, promise, ihabol namin yung documents. No, the document should have been there at the time of the submission of the eligibility of documents. Hindi siya pwedeng habol. You are right if you're disqualified. You are right if they're bids. If you are right, if you also deny the request for reconsideration. So any brief statement of facts by the aggrieved must be a statement of what was the wrong that is done to him in accordance with the law. Hindi yung hindi lang kayo mabait, okay? Then the issues to be resolved. Ano ba yung issue na i-resolve? Kasi minsan, the problem is, people actually think that protest and request for their consideration is just an opportunity for them to whine. No? There's just an opportunity for them to complain on just about anything about the back. Nagreklamo siya, lahat na nareklamo niya. Hindi naman yun yung issue. Ang issue lang, hindi siya nakasubmit ng updated tax clearance niya. Pero kinokomentahan na niya, nakasali na dun sa protest, pati yung eligibility, integrity ng back members, pati yung kunyari daw, may mga natanggap na benefits, hindi naman yun yung issue niya. So, dapat identify niyo yung issue na could be resolved by the hope. Ano ang issue na gusto mong resolvehin? Kung hindi yung hahanapin pa ng hope, ano pong problema niyo? Okay? So, next would be other matters and informations pertinent and relevant to the proper resolution of the protest. Of course, pertinent and relevant to the proper resolution of the protest is the timeliness ng protest niyo. Dapat talaga nakalagay kailan nyo natanggap, kailan nyo kayo nag-respond. Kasi importante yung timeliness. Otherwise, wala na yung right to file protest nyo. And also, that, of course, there's no, you haven't filed your any action or there's no pending action in any other tribunal. Baka mamaya ina-ombudsman nyo na, tapos humihingi pa kayo ng resolution sa protest, yun pala, nasa ombudsman na yung reklamo nyo against kay Hope at Sabah. O, what's the point? Diba? Ina-accommodate ka pa namin na nasa ombudsman na pala kami. Diba? So, yun yung iba kasi, akala nila, more entry, more chances of winning. The more tayong maraming pagrereklamuhan, the more tayong papansinin. It's not like that. So, yung verified position paper nyo, it must be a verified by an affidavit. That the affiant, sino po yung affiant? It's the bidder, no? The aggrieved bidder or contractor na nagrereklamo sa decision ninyo sa back, no? So the affiant has read and understood the contents thereof. Kasi there will be probabilities that yung affiant, hindi naman yan, may mga ganon, di ba? I mean, we know that some affidavits are pre-prepared by the lawyers, yung mga retaining lawyers nila. Tapos, hindi naman, minsan kasi, I have to admit, lawyers have the tendency to put everything, di ba? Especially sa prayers, kung ano-ano pinaglalagay. Hopefully, meron nga namang, baka naman mag-grant, di ba? But no, in procurement, ilalagay lang nila, requirement talaga, ilalagay nila, ano yung totoong alam nila. Yung naintindihan ba niya, pinagsasabi niya dyan, na alam, naintindihan niya, confirm ba siya na correct at totoo lahat ng sinasabi dyan sa affidavit? Kasi baka mamaya, minsan ako, naka-experience kami personally, may protest. Tapos sasabihin mo, bakit mo sinabing hindi namin nagawa to? Andun ka, nakikita mo yun. Sabi niya, ma'am, hindi ko sinabi yan. Ayan, dito sa affidavit mo. Ay, talaga, nailagay lang ng lawyer ko yan, ma'am. Ganon. So, yun yung maging problem. Kung ang affiant, hindi siya aware kung ano pinaglalagay, nag-affects na siya ng signature niya. So, you have to make sure na yung affiant, alam niya yung pinagsasabi niya doon sa verified position paper niya. Also, unverified position paper, pag walang affidavit of verification, anong mangyayari? It is considered unsigned and produces no legal effect and results to outright dismissal of the protest Huwag nyo namang i-ignore. I-dismiss nyo ng maayos. Huwag nyo, baka mamaya dyan, meron sa inyo, member sa back, or kaya si Hope din, may background sa law, sasabihin, that's a mere scrap of paper. The word mere scrap of paper, nag-apply lang po yan sa courts, no? At saka din sa ombudsman, meron ganon, sa ibang court tribunal. But in procurement law, you are required to at least dismiss it properly. Okay? Para alam naman niya na, na-dismiss pala yung protest ko. Hindi yung ano na nangyari sa protest ko. May nangyari kaya doon? Don't let him wonder din yung bidder nyo. Let him know na dismiss siya because he's unsigned and it produces no legal effect at all yung protest niya. Then failure to comply should not be curable by mere amendment of the verified position paper. Now, in legal procedure talaga, yung sa mga court procedures, meron po kaming option to file an amendment, no? Curing a pleading by amendment. Kasi minsan, because of the time constraints, we have to file our appeal, we have to file our petition within 15 days, within 30 days. Minsan, naisipan namin, ihabol namin to, meron palang ganon. I-change namin, i-amend namin. We will file a leave of court. We will file curing by amendment, no? So, ang mangyayari niyan, i-cure namin yung pleadings. When it comes to verified position paper for protest, the aggrieved bidder does not have that option. Kasi baka mamaya sa pagmamadali nilang habulin yung 3 days na request for reconsideration at 7 days na filing of protest, hindi nila naayos yung verified position paper na, hindi na po sila pwedeng mag-correct dyan. Okay? They cannot exchange that, amend that by filing a leave. So, yan po yung nature ng verified position paper. Now, let's go to the resolution of protest. How will the Hope handle when the protest already has reached his level? So after niya ma-receive, diba? So when the aggrieved bidder received the denied request for reconsideration, he only has 7 calendar days to file a protest with payment of unrefundable protest fee, with affidavit, it must be a verified position paper. It must have attached a certification for non-forum shopping and addressed to the Hope. So the Hope shall resolve the protest within another 7 calendar days. No, from receipt of that protest, and the head of the back secretariat, no, shall furnish the bidder with a copy of the decision within 7 calendar days from receipt. So all you need to remember is the timeline, 37777. That isang 3, apat na 7. 7 days for the back to decide, 7 days for the aggrieved bidder to raise a protest, 7 days for the Hope to decide, and 7 days for the back secretariat to furnish a copy of the the aggrieved bidder a copy of the decision. So it is in the form of yan po yung process ng resolution of protest natin. Kailan po sila pwedeng magpunta sa regular courts? Again, they can only go to regular courts only after the protest has been resolved. Any other action na hindi dumaan sa request for reconsideration or protest, yan po ay violation and exhaustion of administrative remedies. As yan, the round po yun para i-raise nyo po yan sa answer nyo. Right now, the rules of court already eliminated Rule 16, which is the motion to dismiss. You could have raised that for motion to dismiss, but instead, you will be required to answer. No? If in case there is complaint against you, you will be required to answer. But in your answer, you can raise that as a defense. It never. Remember, pag may magreklamo sa inyo relating to your decisions sa back or relating to your decisions as Hope, if they ever may matyagang Hope dito, which of course, they're so busy, I doubt they could take time for that. Ang always yung titingnan talaga, dumaan po ba yan sa request for reconsideration? Nag-file ba yan ng request for consideration? Nag-file ba yan ng protest after? Na-comply po ba nila yung requirements, both ng request for consideration and protest, both in time, payment of protest fee? Pag hindi, that is a good defense on your part para ma-dismiss ang complaint against you. Okay? That is a good defense on your part. Let's keep quiet. So, ito po yung tanong. What if there was a request for reconsideration? And what if there was indeed a protest being filed, but it was not verified or the protest was not paid? Then the respondent shall be considered as to have failed to avail of the correct protest procedure before it filed its petition for whatever, like annulment of the award or petition for certiorari or whatever pleadings they will file before the regional trial court, no? So, whatever nila ipafile, pag may mali sa timeliness at may mali sa procedure na hindi nila na-follow, that is still a defense on your part. No? Any award, always remember that you cannot award any contract before before all petition, kung ilan man ang petitionan, protest, before all protest, kung ilang protest man ang natanggap nyo, shall be resolved. So, dapat i-resolve lahat ng request for considerations and protest before you can award any contract. Why? Because any decision in the request for reconsideration and protest could actually go the other way, di ba? Pwede nga namang makita later ni Hope, ay, oo, may mali, may hindi nasunod, hindi siya dapat i-disqualify. So, kung na-award nyo yun, dinidetermine nyo na lowest calculated and responsive bid, may contract na, that would be complicated. Kaya i-award nyo lang yan pag na-resolve na lahat ng protest. Kasi things could go the other way and you have to go back to the table to open their bids. Especially yung bid form nila. Diba? Especially if it's their eligibility that was in question na nagpa-disqualify sa kanila. So yun po yung mangyayari. Resolve mo na all protest before any awards can be made. Ako, personally, I will say this. I've encountered a lot of LGUs, especially yung mga DILG-funded DILG-funded projects sa LGUs, na tapos naging problema yung bidding nila, may protest pala. Tapos sabihin namin, uy, this is not a ground for disqualification. Ba't ganun? Tapos sabihin, ma'am, tapos na yung may kontrata na yun, andun na nga yung bidder. Sabi ko, bakit andun na yung bidder? Hindi nyo pa na-resolve yung protest. Well, that's really questionable. You would be lucky if the bidder is a new fight or the contractor is a new fight. Wala siyang alam. What if he's also a veteran? Veterano yan. Alam ang batas. They're also attending seminars like you. No? So yun yung maging problema. Madimanda pa tayo. Okay? So the protest fee, here we have the protest fee. Punta tayo sa slide ng protest fee. Yan po, kinompute ko po talaga yan kung hindi ba lalagpas. Actually, it's very correct lang. Yung more than 50 million pesos to 200 million pesos na protest fee, 500,000 is bigger than 0.75% of 50 million pesos to ABC. So, yan talaga, very equitable siya yung protest fee. Kinukumpute namin talaga yung katuwaan lang. Baka naman lugi ka pa, no? So, yan po yung susundin natin. Take note po, hindi po natin ito. Ito po talaga, fix po to ha? Kasi by resolution ito. Fix po yan. Huwag yung sabihin, malaki. Malaki naman masyado yung 500,000. In the first place, if they can bid for a project that is more than 50 million pesos, no? It means they can afford that protest fee. Ang point kasi niyan, para hindi din maging maabuso yung protest. Kasi it's delaying, di ba? Government project do not delay. If hindi natin lalagyan ng protest fee, ma-abuse yan just to delay the contract, just to delay the project. So we have to make sure, kung sila, they really believe that they have a ground to protest, they will really be willing to pay for that protest fee. Kasi po business yan eh. They will be willing to they will recover. Kasama po yan sa mga expected na incidental expenses nila. So, we have here knowledge check muna. Okay, knowledge check. Pakibasa lang po yung knowledge check.
Yes po. All right. We are now on our first knowledge check. So same routine po, guys. You have to choose your answer in our Zoom polling feature. And the question is, the question
Basahin lang po.
is the non-payment the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Is it true or false? Again, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes justifiable basis for the hope not to entertain a protest. Is it true or false? Again, kindly choose your answer po in our Zoom poll feature. Alright, again, while waiting po sa majority to answer the poll, again, feeling ko naman guys, alam nyo na ang lagi kong nare-remind sa inyo pong mga participants, do not forget to evaluate our resource speakers. Alright. We're going to close our Zoom polling feature in 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. Poll closed, and the result, ayun, sorry, hindi ko makita sa screen yan. We have, ma'am, attorney, we have 83% answered true, while 17% answered false. Ma'am, ano po ang tamang sagot para po sa ating question number 1?
Actually, no, I like how they were not trapped with the double negative. Kasi marami nalilito dahil sa double negative na question. Yes, the answer is true. The non-payment does not toll because the payment does toll, no, the prescriptive period for filing a protest. And it becomes a justifiable basis for the hope not to entertain a protest. Tama po siya. Actually, it's a double negative and it could be confusing for some. Kasi di ba, non-payment for does not toll, it's intended para makita kung you were paying attention talaga. Pag yung hindi pagbabayad ng protest fee, hindi po nakakatigil ng prescriptive period sa filing a protest. So kahit sa 7 days to file a prescriptive protest after you receive your request for reconsideration being denied by the BAC, pag first day pa lang, na-deny ng BAC yung request for reconsideration ko, first day pa lang, sabit agad siya ng protest mechanism niya. Hindi ibig sabihin stop yung prescriptive period kasi hindi niya nabayaran yung protest fee. So tuloy-tuloy pa rin yung pagtakbo hanggang 7 days, hanggang 8 days. So sabi niya, nag-file ako ng protest within 7 days. Bakit hindi tumigil? Bakit hindi na-result? Kasi ma'am, expire na yung 7 days. Hindi kayo nakabayad ng protest fee. So hindi siya nagsastop yung period for you for the 7-day period deadline ng filing of protest. So tama po siya na true po ang sagot. It's a double negative.
All right, thank you so much po, Attorney Aiza.
Bakit you did not answer? Kailangan pala ako mag-answer din kasi you did not answer this question.
You're going to expound further the correct answer at the knowledge check po. All right, thank you po, ma'am. Again, let's continue our discussion po.
Okay, I was told na medyo huli pala yung nag-text si Miss Jo, medyo huli pala yung boses ko. So I will just make sure na to tell you next slide. So okay, on the slides for uniform guidelines, tapos na po tayo sa protest. Now, if you, again, I will remind you that the protest mechanism is directed towards the decision of the BAC in any bidding procedure. Now, let's go to blacklisting. Ito pong blacklisting, iba naman to. This is the action by the BAC towards the bidders. Ito baliktad naman. Tayo naman ang mag-initiate dito or kung sino man yung may nakita against aggrieved bidder. It's either the BAC, an observer, or other aggrieved bidders against another bidder who may have committed unlawful acts. No? So baliktad, dati tayo nireklamo, ngayon tayo naman ang mag-handle ng proceedings, initiate nito. Pwede lang tayo. So there's guidelines from GPPB, 2 guidelines issued, one in 2017 and one in 2020. So first, we will read that, the uniform guidelines and blacklisting. It is pag may mga complaints ng dating sa inyo directed against other bidders, this is the time you have to secure a copy of this, okay? GPPB Resolution number 40-2017. This is the approved revised uniform guidelines for blacklisting of manufacturers, suppliers, distributors, contractors, and consultants. Now, you say, ay, meron na kami dyan. Remember, this is a new resolution. It's worth a read. Huwag ko nating sabihin, naka-experience na kami dyan, nag-blacklisting kami dati, alam na namin ang gagawin. There is a new procedure here laid down. This one is not customized. This one is not handed down to us. This is uniform sa lahat po ng agencies ng gobyerno na nag-handle ng procurement. So it includes LGUs, NGAs, SUCs, okay, GOCCs. So uniform po ang guidelines natin sa blacklisting. Why we have to make sure that it is uniform? It is also for the benefit not only of us na hindi tayo mahirapan, but also for the private entities dealing with us sa gobyerno, yung mga private individuals. Kasi kung paiba-iba yung process ng blacklisting, baka mahirapan po yung mga private entities na magreklamo sa kung may mga makikita sila. Okay? Especially yung observers natin may come from mga anti-corruption groups. So baka mahirapan sila kasi paiba-iba. May customized ba na blacklisting rules? Wala po. Uniform po yung guidelines natin. It took effect last September 4, 2018. Now, next slide. Ito naman po ang GPPB Resolution number 14-2020. Ito po yung nag-approve naman ng prescribed form of blacklisting order. Meron na po tayong prescribed form of blacklisting order for the implementation of the online blacklisting portal for posting and updating of status of blacklisted entities. Now, this one makes sure that yung mga data po na kailangan for the uploading of blacklisted entities in the online blacklisting portal is andyan na. Para the moment mag-submit po kayo ng blacklisting form of blacklisting order nyo, yung form na isasubmit nyo, kumpleto na siya ng details, hindi na pabalik-balik at ma-implement ka agad yung blacklisting order nila na 1 year or 2 years. Okay? Bakit? Kasi time is of the essence. While there is delay in uploading their names of these black entities in the online blacklisting portal, these people could still actually participate in some government procurement activities. And these people are dubious. They have problem with their credibilities, of their integrity. Tapos i-allow natin siya mag-participate. That would be disadvantageous to the government in the end, right? So as soon as possible, pag nag-finalize na yung order, final executory na siya, na-issue na yung blacklisting order, dapat ma-upload agad yan. Kaya dapat complete po yung data na isasubmit nyo. And for that, to make sure that will happen, the GPPB made sure na meron tayong prescribed form with all the data that's needed that's there. No? It took effect last August 7, 2020. Now, how do we differentiate? Ang dami, ma'am, ano po ba talaga ang proper term? Blacklisting or suspension? Ito po kasi siya. Suspension precedes blacklisting. Nauna ang suspension before pa siya mag-blacklisting. Why? Because due process po, meron po tayong process na ino-observe. And during that period po, hindi po pwedeng walang suspension muna. Kaya ang tawag po natin sa suspension is interim penalty, while blacklisting is the administrative penalty itself. Yan na po yung final na result ng yung blacklisting procedures nyo, yung blacklisting mechanism na nag-result ng suspension na while waiting for it to be final executory, suspension muna, after everything has been resolved, saka na po yan blacklisting. Pag sinasabing blacklisted, may blacklisting order na talaga yan. So you see, blacklisting is the administrative penalty disqualifying a person or an entity from participating in any government procurement for a given period. So meaning lahat ng procurement activities ng gobyerno, hindi na po siya pwedeng sumali pag blacklisted na siya. Okay? So it could be for 1 year, it could be for 2 years, it could be for more kung paulit-ulit na siya, no? Kasi nag-accumulate na. But suspension naman po is just an interim penalty. Ito po yung mauna. It's an interim penalty imposed for infractions, next slide po, yung suspension, definition of terms, for infractions committed by a bidder during the procurement. Ay, salamat. Kasi na-unmute ako. Mag-chat pa sana ako. Na-unmute ako. So, yung suspension po, yan po yung interim penalty imposed for infractions committed by a bidder during the procurement stage. So, whereby such a bidder is prohibited from continuously or further participating in the bidding process of the agency. Kung saan agency siya inirereklamo, saang agency siya nagkubit ng unlawful acts, doon po siya masususpend. While ongoing pa po yung motion for reconsideration, habang may chance mag-file ng motion for reconsideration, pending is motion for reconsideration. Okay, inalis ko po yung video kasi akala ko yung nakakapahina po siya ng ng network signal. So yun po yung suspension while after the decision of the hope, but pending the filing of a motion for recon, pending the motion for reconsideration, pending the filing of an appeal, pending the duration of the appeal, at before it became final executory pag hindi na-reverse. Pag na-reverse po yan, it means hindi po kayo mag-blacklist na. Bakit? Kasi hindi nyo naman pala misinterpretation lang or misappreciation of facts. But if the decision, even sa motion for reconsideration or appeal, is not in favor of the suspended entity, either a sole entrepreneur or a corporation or a cooperative, then after it becomes final executory, sasubmit na yung blacklisting order to the online blacklisting portal, and he will start serving the 1 or 2 years as prohibition or disqualification to participate in all other government. So kaklaruhin ko po, yung suspension po, interim lang yan. Sa agency nyo lang. Kunyari, sa LGU ng Kalapi, send my hello to Mayor Herrera. Kunyari, sa LGU ng Kalapi, may sinususpend sila. Hindi pa lang po yan participate ng procurement yung bidder na nasuspend sa Kalapi lang, LGU Kalapi lang. Pero pwede pa po siyang mag-participate sa bidding procurement activities ng ibang, kunyari sa Ubay or sa Mabini. Pwede pa po siyang mag-participate. Pwede pa po siyang mag-participate sa DILG din or sa provincial government. Pero pag blacklisted na po siya, hindi na po siya pwedeng mag-participate ng any procurement activity ng gobyerno mula Apari hanggang Hulo. Okay? Bawal na siya. Hindi na siya pwede. So, yan po yung requirement yan po yung difference ng blacklisting at suspension. Now, sino naman yung blacklisted person or entity? Of course, the person who is being blacklisted. Na blacklisted ka, you were issued a blacklisting order, now you are blacklisted person or entity. So sino yan? It could either be a natural person or a juridical person, no? So pwedeng tao siya, pwedeng korporasyon siya. Or yung tao na related sa mga korporasyon, yung may mga may mga controlling interest, yung mga shareholders niya. Kasama po yun. Now, appellate authority. Sino naman po yung appellate authority? Now, not every agency has, ito po, next slide, sa definition of terms pa rin po tayo. Not all agency has an appellate authority. Okay? Depende po yan sa structure nyo. If you want to know if you have an appellate authority above the hope, you will have to go back to your organizational structure. Ano yung organizational structure nyo? Tingnan nyo, if yung mga decisions ba ng hope nyo is subject to appeal to other government agencies, subject ba appeal na yung decision ng mayor sa DILG? Hindi po. Bakit? Kami supervision lang po kami sa inyo, wala po kaming control. So, since supervision lang kami, wala po sa amin pati yung power pag-overturn ng mga decisions ninyo. You have to, kung may makita man kami mali, we will let you know and you have to do it yourself. Okay? You have to correct yourself. Pag hindi pa rin, then that will be another person. Hindi pwedeng kami ang personal na aarte sa inyo. Kaya hindi kami yung appellate authority niyo. How about the governor? Still the same. The governor exercises direct supervision over you, but they do not control you. Yan po yung essence ng local autonomy. We'll have to emphasize that kasi adjust kayo lahat. May local autonomy po tayo and because of the autonomy, wala pong may appellate authority sa LGU. Okay? So the next thing to do, sabi nyo, so walang may appellate authority. Hanggang motion for recon lang sila. So ano mangyayari sa nagrereklamo? That's where the courts come in. Okay? That's where the courts come in. Diyan na po papasok yung mga remedies under the revised rules of court. So hindi pa rin totally hopeless yung nagrereklamo na yung na-suspended at blacklisted na personality, na blacklisted entity. Okay? So the part, hindi ko na lang kasi tinatagalog ko na eh. Automatic na po, pag yung decision nyo, pag wala kayong appellate authority above you, automatic na po siya final and executory kasi wala nang appellate authority. Now, what about the listing? Definition of terms pa rin po tayo. Ito po yung delisting. Actually, this is not your problem. Kasi supposedly, madidetermine ng blacklisting portal pag nag 2 years na or 1 year na tapos na yung period niya. Kaya yun po yung reason bakit yung blacklisting order niya dapat nakalagay yung day 1. Bakit? Doon po kami kasi madidetermine kung kailan din matatapos yung blacklisted status ng entity. But that is something that should be the concern of the blacklisted entity kasi negosyo niya ang apektado, di ba? If hindi pa siya ma-remove, yung delisting tip, basically, it's the removal of a person or entity from the consolidated blacklisting report. If dapat automatic siya, but if hindi siya automatic na nawala doon, then you should try to contact the GPPB on that, no? Kasi yung entity naman, na-submit naman nila yung blacklisting order properly with the right data. Baka nga may technical problem na din yan. Kasi supposedly, it's automatic na madidelist sila. So, sino po yung scope of blacklisting? As I mentioned earlier, it could be a natural or juridical person. Tayo po mga natural person born out of love at born out of habit ng mga parents natin. Yun naman po mga juridical person born out of particular interest. It could be for profit. It could be for community gains. So, sino po, pag hindi po natural person, sino-sino po yung mga yan? Yung mga partnerships, no? Yung mga cooperatives, yung mga corporations, joint venture consortium. So, now in your case, most MLGUs, you encounter lots of DTI-registered personalities. So, sila, ang mga DTI-registered personalities, they're considered as sole entrepreneurs. So, direct sa kanila yung blacklisting. But not only that, under the law, under RA 9184, not only the bidders, yung registered na, DTI-registered na owner ng business, ang blacklisted, kundi pati na rin yun ang spouse. Why? Because in the Philippines, we have either conjugal or absolute community of property. They sleep on the same bed. It is presumed that they know what the other is doing, and the integrity of one is known to the other. Bakit tayo may blacklisting? It's actually a reprimand to them not to keep their integrity when they deal with the government. So when they deal with the government, yung spouse nila, alam nila yan. Presume yan ng batas na alam nila ang pinaggagawa ng mga partners nila. Okay? So kasama yung mga asawa. Kahit si husband may ibang negosyo, hardware, si asawa naman, medical supplies. Pag na blacklisted si husband dahil sa construction bid niya, pati po si asawa na may medical supplies, kasama po yan sa na blacklist. Okay? Then how about partnership? Kasama ang buong partners. Hindi pwede yung representative partners lang. Silang dalawa, silang tatlo na partners. How about the cooperatives? yung pong mga board of directors, yung general managers, at yung chief executive officer. Why? Because they are part of the decision-making body. If empleyado lang sila, hindi naman sila kasama sa mga nagde-decide, of course, they're not part of them. But those who are part of the decision-making body, yung nagde-decide at nag-a-act, kasama po yan sa blacklisted. So if may negosyo, yung isang board of director ng cooperative, may sarili siyang negosyo, na sole entrepreneur din siya, ay kasama po yun sa blacklisted. Masasama po yun. Okay? Then, joint venture consortium, corporations. Itong corporations, depende po yan. If at least he has 20% controlling interest. Kung ordinary trader lang siya na bumibili-bili, trader investor, bumibili-bili ng mga stocks or shares, ay hindi po automatic na, ay may share siya sa ganyan na construction, ay blacklisted yun, kasi dapat ano na siya. No, dapat may controlling interest siya. Dapat nga voting siya. Diba? Meron siyang at least a certain percentage of share na masasabi natin he knows what the company is doing and he agreed to it. Okay? So yun. Knowledge check. Again. Knowledge check po tayo.
All right, we are now on our second knowledge check for our topic this morning, and the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it true or false? Again, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it true or false? Kindly choose your answer po in our Zoom polling feature. Also, while waiting po for the majority to answer our poll, may I remind everyone to please change your name po to the prescribed format of our training, which is the MLGU name underscore your name, so that we can properly monitor po your attendance in this event. All right, we're going to close our Zoom poll feature in 5, 4, 3, 2, and 1. There we have it. We have 69% answered true, while 31% answered false. Attorney?
Oh, yeah. Actually, I also answered no. The answer here is false. Actually, this is very tricky. If you check the whole statement itself, it is almost as if it is true. Why? Because everything there that is said about blacklisting is correct except for the word interim. Remember, blacklisting is an administrative penalty. It is the final penalty. Interim penalty is the suspension. So yan lang po ang change nila sa phrase at yun na po ang nagpa-false. Okay, it's quite very tricky how they construct the sentence itself. It's to check if you are being attentive to details din na makikita kahit maliit lang. So I understand why others answer. Most of you answered true because everything there is actually correct. Prohibited from further participation in the bidding process of ito pala binago din no during competition whereby such contractor is prohibited. Ito dapat ang sagot is suspension. Okay. Everything here is correct. It's an interim penalty imposed for infractions committed whereby such contractor is prohibited from further participation in the bidding process of an agency. Tama po lahat yan except for the first word. It's not blacklisting, but it is suspension. Pag blacklisting, it is administrative penalty. Pag suspension, it is interim penalty. I know you got the idea already of the difference between blacklisting and suspension. It's just that how it is phrased is very tricky. So yeah, we should take notice of. We should be more careful next time when we answer.
All right. Thank you po, Attorney. Well, you know what, guys? Yung activity natin kanina is already a warm-up for you to have your looking skills and everywhere, yung magnifying eyes natin. So next time guys, on our next knowledge check, please read first the question before choosing your answer. All right. Without further ado, let's continue our discussion po.
Okay. Earlier, we talked about protest. No, we mentioned that protest has two stages, the request for consideration and protest proper. But in blacklisting, it's not two stages, but two instances. Okay, what are the two instances? When are these two instances applicable? Kailan applicable ang isang instance? Kailan naman applicable yung isang instance din ng blacklisting? So blacklisting could happen, one, during procurement stage, and second, during contract implementation stage. So hindi na po ang blacklisting during the bidding, may mangyayaring blacklisting. Minsan may contract na, may na-award na, tapos there are things that have been found out related to the contract or related to the bidder, even outside of a contract itself, di ba? So, yun po yung dalawang instance. Merong blacklisting during procurement stage, it's quite lengthier, whereas there is a blacklisting during contract implementation stage. It's actually a shorter proceedings, but there are a lot of considerations, especially in the whether or not to terminate the contract, no? So, first, let's go to the grounds for blacklisting during procurement stage. Next slide. Yan. Ito po yung mga listed na to na magandang kulay. Yellow, green, blue, and orange. Ang grounds po for blacklisting during procurement stage. Ito yung mga pinagagawa ni bidder habang hindi pa na-award sa kanya. And some of this may surprise you. Ako, sasabihin ko, when I first started in the procurement, then, na-surprise ako. Kasi because I was told before it's natural. And you know, most of us, we learn from watching our seniors. We learn from watching how our government is, what they say, how they do things. Tapos bawal pala yun. Kaya let's be careful kasi we tend to follow monkey see, monkey do, mas madali talaga. No? Monkey do, monkey follows. So, dito po siya, mga practices na laging na-abuse na mga bidders na dapat aware kayo or at least nakabantay kayo kung meron man. Or kahit kung hindi, dapat the moment malaman nyo, dapat may action kayo. Hindi yung pipikit lang kayo. Okay? So, submission of eligibility requirements containing false information or falsified documents. Okay? Kasama po siya because we go ahead with this topic kasi dapat usually nauna yung penal, civil, and administrative provisions ng RA 9184. Ito po ay kasama sa mga fraudulent acts, no? May misrepresentation intended to defraud the government, okay? So, yan po, bawal po siya because it is intended to defraud the government, and the presumption is, why are you misrepresenting yourself? Why are you using false information? Because you must be ineligible. There's a presumption na baka hindi ka eligible o baka may mga hindi ka talaga na reliable or credible na bidder or contractor. Kaya you have to resort to that. So we have to protect the interests of the government by making it a prohibited act. Then submission of bids, not only eligibility requirement na containing false information, but submission of bids that contains false information or falsified documents, or the concealment of such information in the bids in order to influence the outcome of eligibility screening or any other stage of public bidding. Hindi kinoconceal pa nila, tinatago nila yung added cost para sila yung mababa. Yun pala, may mga added cost na pinapasok nila bigla. No, that's concealment on their part. So that is a lawful exaction. Hindi nyo yan sinama, di ba? So yung sa submission of bids din, or kaya meron silang mga not only sa eligible, meron silang mga may mga problems sila sa ibang previous projects nila, no? So refusal to clarify or validate in writing its bid during post-qualification within a period of 7 calendar days from receipt of the request for clarification. Ito naman yung sila yung nag-lowest calculated and responsive bid, lowest calculated bidder. So sila yung unang in-undergo ng post-qualification. But they refuse to clarify, no, to validate in writing its bid during post-qualifications. Hindi na sila cooperative. No? So why is this punishable? Because there is a presumption that there is collusion. No? Baka may usapan or nangyayaring arrangement or scheme sa likod. Uy, during opening on submission of bids, nakita na, hala, mas mababa si C sa akin. Sabi ni A sa sarili niya, kausapin ko to. So kahit siya pa yung lowest calculated after ng bid evaluation din, kahit siya pa yung lowest calculated bidder, kakausapin ko yan para hindi na niya i-validate yung ibang papers niya. So there is a presumption that there is collusion, and that is again presumed to be disadvantageous or contradictory to the interest of the government. So any undocumented, unsolicited attempt by a bidder to unduly influence the outcome of the bidder in his favor. So yung unsolicited attempt by a bidder to unduly influence, it could be by corruption, it could be by coercion, and those are prohibited acts under RA 9184. Then allowing the use of one's name or using the name of another for purposes of public bidding. That is issue to lagi, no? It's a good thing that PhilJobs now is requiring also platinum registration. Kasi yun nga, tapos yung pickup din license, pwede nyo yung i-check. Don't ever say na hindi nyo alam, nagre-rely lang kayo. During eligibility check, during opening and submission of bids, you are allowed to rely on their representation. But you have a chance during post-qualification to check, verify, validate their claims. Kaya sinabi nyo, hindi naman namin nag-rely lang kami dito. Anyway, may OSS naman. But still, you have to exercise good faith. You have to exercise highest standard of ethics in doing your job. You have to check kasi available naman yung information online sa BIR, sa PCAB, no? So you can check if these people really are what they represent. If totoo ba talaga na triple A yan, baka naman mamaya bilang yan, hindi pala siya qualified sa PCAB license niya, nakikigamit lang, no? Take note that is a prohibited act, that even the person allowing another person to use his license can be liable, no? So withdrawal of a bid or refusal to accept an award or enter into contract without justifiable cause. Take note, justifiable cause. Because there can be reasons then bakit hindi pwede, di ba? Like for example, may mga cases of insolvency or force majeure, di ba? Unforeseen circumstance, no? Contingencies. So, bakit siya bawal na mag-withdraw or mag-refuse to accept an award? In the first place, meron siyang bid security. Hindi pa ba enough yun? Oh well, you can forfeit the bid security, but still they still undergo the blacklisting procedures to penalize those who are wasting our time. Sabi nga, di ba, government project do not delay. You are wasting our time. Nag-post-qualify po kami sa'yo. We spend so much time evaluating your bid and you will not accept now the award? Bakit? Nabayaran ba? Nabili ba? Again, those presumptions can be true or not, but in the end, these provisions in the law, andito siya para protektahan ang interes ng gobyerno. Okay? We are not being mapang-api sa mga bidders, but we are just protecting the interest of the government. They should not bid if they are not sure they can meet our requirements. Then refusal or failure to post required performance security within the prescribed time. So yun, especially, not only this, yung extension talaga ng performance security din. Dapat mag-submit siya because you are waiting, no? Meron tayong mga day one yan eh. Meron tayong timeline. If you allow a bidder na kung kailan lang siya gagalaw, doon lang din, hintayin nyo lang siya, then kayo din po ang magkakaproblema niyan sa completion or especially the non-completion. Baka mamaya, may problem talaga yung taong yan sa ibang contracts niya. May mga slippage na siya, no? So all other acts that tend to defeat the purpose of the competitive bidding, such as habitually withdrawing from bidding or submitting bids or patently insufficient bids for at least 3 times within a year except for valid reasons. I remember some people mentioned it to me when I was still a student before, na parang business daw yan, nagpapabayad, nakikisali. And that is very dangerous, no, to the business. It raises the price Kasi yung iba, not only it defeats competition, remember you studied your government procurement 101 principles of procurement. Diba? One of the principles of procurement, kaya nga default mode talaga natin is competitive bidding, is because we have to have competition. Why? Competition is important to make sure that we get value for money, that we get the best item for the best price that we can offer. So, kung merong mga ganong mga actions ng mga private enterprise which defeats competition or na-manipula nila, then that is punishable under the law. They are playing with a system. So they should be punishable. Na ano pa yan, di ba? That will be an added cost to the whoever awarded contractor later on. Tapos sabi niya, babawiin ko yung binayad ko dun sa isa. No? So we will not allow that. Now, what are the sanctions for blacklisting during procurement stage? Next slide. Next slide po, ano yung mga sanctions natin? Of course, automatic yan. Since it's still during procurement stage, buhay pa po yung bid performance, bid security nila. Nagkaano-ano na ako. So yung bid security nila, ipo-forfeit nyo yan on your favor, no? So another would be, of course, if first offense, first time nyo lang na found na blacklisted, for 1 year lang muna, hindi siya maka-participate in any government procurement. But if second na niya, di ba, parang nasasanay. But never think that it's impossible. Ay, na-blacklisted na yan, man. Nangyayari talaga yan because businessmen as they are, they tend to take more contracts than they could chew. Parang, kaya ma-afford natin yung chini-cheap pa nga nila yung NFCC nila. No? Hindi proper yung computation nila ng NFCC nila kasi tinatryin pa nilang hinahide yung ibang contracts nila o pending contracts kasi nga gusto nilang makapasa. So, na-blacklisted pala sila dun sa isa dahil nagkaroon sila ng nag-default na sila, hindi na nila natapos yung project. Tapos, dahil hindi na nila natapos yung project, hindi na sa nabayaran, hindi na rin nila nasimulan yung isang project, na-blacklisted din sila sa kabila. No? So, it could happen. This is really possible na magba-blacklist sila sunod-sunod. Hindi pa natapos yung nung 1 year, sumunod na yung 2 years na suspending declaration. For some, it's not bid security, but bid securing declaration. So this is without prejudice to the imposition of additional administrative sanctions as the internal rules of the agency may provide and or further criminal prosecution. Remember, it is not only our 9184 that provides administrative, penal, or civil sanctions on relating to procurement, but also RA 3019, okay? But also, revised penal code. So marami po tayong batas na nagpe-penalize on any acts committed. But of course, RA 9184 is more specialized on procurement. Kaya pwede pa rin silang wala pong double jeopardy dito. Okay? Kasi nga po, administrative sanction siya. May double jeopardy, yung requirement po ng double jeopardy, sa penal, criminal lang po yun, pag same law. In fact, they can even be charged either RA 3019, later we will discuss, or RA 9184. Anyway, so blacklisting naman during procurement stage. So how do we initiate? With all the talks about blacklisting, the penalty, ano yung mga grounds? Paano naman po, pag may nakita kami talaga na grounds, pwede po ba kaming mag-initiate ng blacklisting? Yes, you can as back. Yung mga duly authorized observer nyo na nakikisali, nag-attend pa ba yung mga observer nyo? Baka hindi na nag-attend yan na kasi paulit-ulit na o kaya hindi naman nila naintindihan kasi hindi naman sila fully furnished ng mga documents. So remember, you are to invite your observer from day one. And day one is your pre-bid of course, not of course during advertisement kasi pinapost nyo lang yan sa PhilJeps. Sa pre-bid conference, dapat andun na sila. Sa pre-prop conference, hindi sila kailangan doon. Kasi nga, baka hindi pa matuloy, di ba? Baka nga nag-pre-prop kayo tapos hindi nyo naman pa pala i-procure kasi hindi pa needed. So, sa pre-bid conference, dapat andun na sila hanggang all, yung invitation nyo, dapat all stages of procurement. So now, if they were there and they were, for example, during cigarette breaks, of course, they're not supposed to smoke within government premises. No, kunyari, doon sa tapat ng building. So, kunyari nagsusmoke sila, si observer, tapos nakita niya yung ibang, na-identify niya, ito yung bidder kaya to? Tapos naririnig niya ang usapan. Can he initiate complaint? Yes po. Bakit hindi? It's a personal knowledge on his part. How about other bidders or prospective? Tinakot po ako. Sinabihan ako pag hindi ako atras, ganito daw, ganito. Pwede ba sa mag-complain? Yes din. Pwede sa mag-complain. So, any bidder or prospective bidder, duly authorized observer or the back can initiate an action. Yung tricycle driver na nakarinig sa usapan, pwede ba siya mag-initiate? Hindi po siya kasama. Kahit dinig na dinig niya yung scheme at arrangement at collusion na nangyayari, hindi po siya, pwede niyo siyang gawing witness if you like. Pero hindi po siya mag-initiate sa action. Pwede siya prosecutin ng affidavit. Kasi specific po tayo, yung any bidder, aggrieved bidder, duly authorized observer at back members lang. Okay? So back, what will happen after complaint has been filed, no? An action for blacklisting has been filed. Then the back shall notify contractor in writing. So, paalam niya dun sa inireklamo na contractor or bidder or manufacturer in writing after verifying existence of grounds. Kasi baka naman yung inireklamo, wala dun sa grounds. So, titingnan, pag may na-receive yung back na complaint, titingnan niya yan, andun ba sa grounds for blacklisting? Pag wala, automatic wala na. Pag andun, saka siya magna-notify in writing to the contractor. What will he notify the contractor about? It's that the complaint has been filed. Uy, may reklamo sa iyo. That is the opportunity to show cause. Sagutin mo to. That a hearing shall be conducted upon request. Pwede po tayo mag-hearing kung i-request ng inirereklamong contractor. Then the consequence of being suspended and blacklisted. Pag hindi po kayo sumagot, baka po kayo masuspend or ma-blacklist, matatamaan po ang negosyo nyo. Sayang naman. And right now, there's already mandanas ruling, no? Paparami na ang pera ng LGUs. Mayayaman na yung mga LGUs. Mahirap na hindi LG job. So, kaya may nadagdagan na yung pondo ng mga LGUs. Dami na yung projects nila tapos hindi sila makasali. So, yan. Sayang po yan. Opportunity. Kaya sagutin nyo na po ang reklamo sa inyo, Mr. Contractor. So, si contractor, he has the option, no? He has the option either to submit an answer or not to submit an answer. Kasi di naman sa pilitan. Kung ayaw niyang sumagot, sobrang confident siya na there is no ground against him, that it's all, then that is up to him. Kasi isipin niya, sige lang, may remedy pa naman later. No? Baka confident siya. But, no, wala pong time extension niya na within 5 calendar days after malaman niya na may complaint against him, he should answer. Wala po tayo motion for extension. Pang-korte lang po yan. Kasi bakit? Wala naman kayong, hindi naman to main job ng mga back ang mag-litigate at may hope mag-litigate. Tapos patagalin nyo pa? Magdi-deny pa siya? Iisipin niya pa kung anong form ng pagdi-deny ng motion for extension nyo? Wag na. Excuse me. So, what if the contractor does not submit an answer? Automatically, there's no request for hearing then. Kasi hindi nga siya nag-answer, di ba? So, if he does not submit an answer within 5 calendar days from written notice of the back na may reklamo against him, then the back shall recommend to the hope. Automatically, the back shall recommend to the hope the suspension of the contractor and therefore feature of bid security. Sasabihin niyo, automatic ba yan? Hindi man lang titingnan ng back na reklamo. Remember, there is no answer. And any complaint na verify na po ng back kung nag-exist yun as a ground for blacklisting. So, hindi na niya babalikan yun kasi wala namang counter na argument from the agreement, from the answer. So, the back shall recommend to the hope na isuspend si contractor at i-forfeit yung bid security. Within 15 calendar days from the receipt of the back resolution and records of back proceeding, then the hope shall determine the existence of a reasonable cause. If makita niya walang reasonable cause, yes, there is a ground, but there is the ground that is mentioned there, hindi siya nasuportahan ng allegations. Okay, walang reasonable cause. Okay, so i-dismiss yun ni Hope. Okay? Pag hindi naman, pag nakita naman niya, yes, there is indeed an existence of reasonable cause. Yung ground is supported by law, is supported by allegations of facts, is supported by testimonies and evidences, or records of the proceeding, then the Hope shall issue the suspension order as recommended by the BAC, as well as the forfeiture of bid security. Yun po ang mangyayari pag hindi isasagot. Mas maikli yung proceedings. Now, if the contractor decides to submit, sabi niya, may laban ako, delikado to sa negosyo ko, no? So the contractor shall submit again within 5 calendar days from receipt of the identification from BAC that there is complaint filed against him, then he can either submit an answer with a request for hearing or submit an answer without a request for hearing. Now, yung request, kasi ganito po yan, di ba? Sa due process, hindi naman kailangan talaga may actual hearing tayo. As long as both parties are given the chance to submit their position, that is already in administrative law, no? Ang TBI versus CIR is it already meets the compliance, no? It already meets the requirement of administrative due process. Kasi nabigyan ka na ng chance, sabihin ang point mo. It is up to you if you will grab that chance or not. So if yes, nag-request siya ng hearing, the BAC shall conduct a hearing. You do not need to wear a robe. Okay? You just conduct a hearing, a simple hearing. You do not need to be bound by technicalities. Naku, baka mag-motion pa kayo doon. Ha? Do not need to be bound by technicalities. Do not worry about. Okay? You just need to hear his defenses, yung allegations ng kabila, yung defenses, if they have further testimonies, if they have further evidences to their benefit. Pag wala, okay, pag merong ganun, isiset nyo yung, pag may request for hearing, kakandak kayo ng hearing by setting the time and date and time for hearing. Wala na pong masyadong ilang hearing. There is no requirement to us how many hearings you will conduct, but obviously, hindi nyo kailangan ng matagal. Kasi you'll just need, even one day would suffice already. Unless you are that, you are that diligent, hindi naman kayo nire-require. Okay? So, remember, this is a blacklisting procedure during procurement stage. So many things at stake. Meron pa kayong ongoing procurement. May ginagawa pa kayo. Huwag kayong pa-delay dyan. Hindi po ito protest na kailangan munang i-resolve bago kayo maka-award. In fact, you can award already. Okay? Kasi this is not about protest. Okay? This is not protest. This is blacklisting. So how about there is no request for hearing? No. Okay? No request for hearing. Then the BAC shall determine existence of fault. Kasi yung una pa lang yan natingnan is yung existence of grounds pa lang. After ng answer, so existence for grounds, ay oo, pwede kang mademanda, pwede ka ipa-blacklist dito. After na nag-respond si contractor, may answer na siya, iba-balance yan. Remember, this is administrative case. Only substantive evidence. Okay? Wala po tayong guilt beyond reasonable doubt or preponderance of evidence. Kahit po kayong mga may legal background, don't make it an opportunity para mag-hearing, to apply all your legal knowledge. No. As long as may substantial evidence on both sides, sino ang mas matimbang, sino ang mas may yung laman, nag-determine ng fault or nag-determine ng lack of fault, yun po yung i-determine nyo. Okay? So, based on the complaints, answer and documentary evidence of facts verified. Based po yun sa complaint na nagre-reklamo, answer ng contractor na nire-reklamo, at documentary evidence na rin. Some of these are available from your office then sa back secretariat, no? And facts verified. Kunyari, meron silang mga witnesses, no? Or hindi nagmamatch yung dates or nagmamatch yung dates sa defense nila. That is very important. Why? It could mean that someone is not telling the truth if hindi nagmamatch yung mga dates at times. Diba? Sinasabi na, ma'am, nakita kami, nandun nga si wala naman siya doon. Paano nyo? So, meaning may gumagawa-gawa ng kwento, no? Para siraan yung isa. So, if the contractor submits an answer, the BAC, and after that, the BAC, whether may hearing or wala, at nade-determine niya yung existence of fault, the BAC shall recommend to the Hope the suspension of the contractor and the forfeiture of the bid security. Okay? Within 15 calendar days, eto, dati merong dito na, what if walang na-determine si BAC na existence of fault? Meron bang bid dito? Actually, lahat yan, ibibigay na niya sa Hope para mag-decide. The BAC has no authority to decide on blacklisting complaints. If you notice, with or without answer, it is always only the Hope who shall decide the finality of a blacklisting complaint. Okay, so within 15 calendar days from receipt of the back resolution and records of back proceeding, the hope shall determine existence of reasonable cause. And it is up to its level only to decide whether to dismiss the case if there is no reasonable cause. Pwede po niyang i-ignore yung recommendation ng back if makita niya na hindi naman talaga, especially like some hopes have vast experience or they are lawyers themselves, no? Matatalino din yung ibang hope, marami na silang mga ganyan. Nakita nila, oh no, back, you cannot do this, we cannot blacklist this person just because of this. So siya ang magdi-dismiss, siya din ang magsususpend if may makita niya na reasonable cause then. So remember back, your role here is only recommendatory. Okay? Your role here is recommendatory and your recommendation hindi po ministerial on the part of the hope to agree with you. If the hope thinks otherwise, then it is up to him. At least kung may reklamo sa kanya, o di wala na din kayo. Bakit you recommended otherwise, yet he still dismissed the case. Diba? Pero pag pareho kayo ng desisyon ng hope, tapos may magreklamo sa inyo, sabay-sabay na kayo maharap sa korte. No? So yun din po yun. So, okay. Notice of decision, the hope shall furnish the suspended contractor, next slide, a copy of the decision immediately after its promulgation. So, contractor is suspended upon receipt of the notice of decision. Sabi nga, ang mauna po ay suspension. Okay? Wala mo ng blacklisting order. Why? Because the contractor that is suspended still has an opportunity, no, for himself. Paano niya ma-observe sa sarili niya? Pwede pa po siya mag-file ng motion for reconsideration. So, the suspension shall, muna natin yung effect ng decision na contractor is suspended upon receipt of the notice of decision. The suspension shall remain in effect during the period of motion for reconsideration and appeal and shall terminate only upon reversal of the decisions by hope or appellate authority. Kasi pag hindi po yan ma-reverse, ibig sabihin blacklisted po yan. Pag ma-reverse yan, ay salamat. Hindi na po siya suspended, hindi rin siya na-blacklisted. No? If no motion for reconsideration or appeal is filed, then decision shall become final and executory after the lapse of 7 calendar days. So, basically, if si contractor hindi na siya mag-file ng MR, hindi na siya mag-file ng appeal, after his receipt thereof, of the decision of the hope, 7 calendar days, pwede na pong mag-issue si hope ng blacklisting order. Alright. So, pwede na po siya mag-issue ng blacklisting pag walang MR. How would I know na walang MR? Kasi yung MR po, sa kanya po yan ipafile. Remember, just like request for reconsiderations, na doon mo ipafile ulit sa back, motion for recons, doon mo din yan ipafile sa home. Pag may mga word po yan na reconsideration, ini-ask nyo po yung person or yung body na nag-decide or nag-resolve na baguhin ang isip niya. So meaning, sa kanya yun, hindi kayo mag-motion for recon or request for recon sa ibang agency, kundi sa person na nag-issue ng resolution or decision na gusto nyong mabaliktad in your favor. So yun po yun, okay? So, of course, malalaman nyo kung may MR na pinafile or wala. Now, if the contractor files MR, then the hope shall resolve the motion for recon within 7 calendar days from receipt. Now, what does the MR has to allege? No, pwede ba yung, sir, maawa na po kayo? Naku po, hindi po pwede yan. Lagi kong sinasabi in every my seminar, huwag kayong masyadong maawain when it comes to procurement. Kasi po, wala pong place yung awa pag kayo naman po ang hinarap ng ibang nagre-reklamo. Especially if aggrieved bidder or authorized bidder or authorized observer ang nag-initiate ng complaint, he will be given copy of all the resolutions or decisions along the way. So, alam niya, nag-file ng motion for reconsideration, wala namang bagong ebidensya yung sinasubmit. Wala namang argument on the decision na hindi siya nag-conform on evidence of facts. Bakit nabaliktad? Ay, baka nabayaran. Remember, that is very crucial, no? Okay lang sana kung nag-initiate ng blacklisting procedure is back, kayo lang naman ang nakakaalam, hindi mapapansin. But if may makakaalam, yun nga ang tagang problem eh. It's not, sometimes then kahit nga within sa procuring entity. Remember, even within the procuring entity, there's always politics. There's office politics. And some people may be after your possession. It's true, diba? Some people may be after your possession, and it could be their opportunity to get you out and waste themselves. Hindi kasi lahat ng umaangat gumagawa ng sarili nilang hagdan. May ibang umaangat nangunguha ng hagdan. So kaya, ingat po kayo ha. Remember, there are always eyes watching you when you're a public officer. You can be sued anytime. It's only a matter of good defense kung wala kayong ginagawang masama or mali. Kahit wala kang hindi nyo intended na masama, pero may mali kayong nagawa. So now, after 7 calendar days, i-decide yan ni back. So if, ni Hope. Now, if i-reverse nyo yan because there is a new evidence, newly discovered evidence, or na-realize nyo, ay, yung decision pala hindi siya nag-conform sa evidence or facts, masyado tayong prejudice, then automatic, nalilift. It's a reversal. So, nalilift yung suspension. No? Susoli na yung bid security na po for fit. So, wala na ding blacklisting order that will follow. But if hindi na reverse, nag-stick si Hope sa decision niya, then suspension will continue pag mag-decide na mag-appeal. Pero if the period to appeal, which is 7 calendar days again, will expire, tapos wala nang appeal, then yung motion for reconsideration, yun na yun, it ends there. Okay? So, how about if the contractor filed an appeal? At your level, there's no appeal. But on others, meron. So, if may file na appeal, then hintayin mo na yun, no? Hintayin mo na yung result ng appeal, then if after 7 calendar days, mag-grant yung appeal in favor of the contractor, lifted ulit yung suspension, wala nang blacklisting order. But if wala pa rin, hindi pa rin in favor of the contractor, then the Hope shall issue the blacklisting order na. Okay? If the appeal is not granted, Hope shall issue the blacklisting order. Tuloy-tuloy na po from suspension, nag-mature na siya. Sabi nga, from worm, naging butterfly na siya. From suspension, naging blacklisting order na po siya. Okay, and forfeit na din yung bid security niya. Okay, so that's it. And let's proceed with the blacklisting. Akala ko may knowledge check. Sorry. Wala palang knowledge check. So let's proceed with the blacklisting during contract implementation stage. I really wish there's a knowledge check here, no? Kasi minsan nahirap din diretso-diretso. It's not about my voice, but it's your, parang gusto ko sana mag-sink in mo na. Parang i-compartmentalize. So, we discussed earlier the blacklisting during procurement stage. Sabi ko, di ba, if protest has 2 stages, blacklisting has 2 instances. 2 beses. Pwedeng mag-initiate ng blacklisting. So, una, during procurement stage, meaning while bidding is ongoing, pwedeng file ng blacklisting complaint. Now, initiate ng blacklisting action. Now, how about meron ng contract? It means, ang instance na ang procedure na ipa-follow nyo is yung blacklisting during contract implementation stage. So, grounds. Ano naman ang grounds? Yan. So, marami po tayong grounds during contract implementation stage. And some of these grounds even relate to the procurement stage. But most of the grounds are actually during contract implementation stage. Yung manner of performance din talaga on their part, no? Marami ako na-encounter dito mga LGUs nagtatanong, mama nang gawin namin, ganito nang nangyari. Sabi namin, so huwag niyong bayaran, i-blacklisting nyo, liquidate, yan nyo yung compute yung liquidated damages. Ma'am, nabayaran na, patay. Bakit nyo binayaran? Wala mo lang retention. So anyway, so what are the grounds for blacklisting during contract implementation stage? Andyan na-award nyo na, may performance security na, or kaya, na-award nyo na, or may contract na ba? Depende. For example, failure of the contractor due solely to his fault or negligence to mobilize and start work. Hindi day one, wala roon. Or performance within the specified period in the notice to proceed. Sa notice to proceed po, nakalagay na yung day one. Day 1, nandun kayo, ready na kayo, groundbreaking. Wala po dun. Or ang andun lang, yung ibang equipments, walang tao. Andun yung tao, wala yung equipments. Hindi nila na-start yung performance nila, no? Walang, di ba, naghihintay si Hope. O, ano na, magsa-start na tayo ng building natin. Excited si Hope. Wala na, hindi nyo na narinig. Ano nangyari kay Hope after kay contractor, winning bidder after pumirma ng kontrata? Wala, naglaho parang bula. No? So failure by the contractor to fully and faithfully comply with its contractual obligations without valid cause, or failure by the contractor to comply with any written lawful instruction of the procuring entity or its representatives. No? So ito yung mga example na, like for example, yung mga instruction nyo sa area. Kasama kaya sa instruction nyo yung paglalagay ng mga barriers, paglalagay ng mga ng mga signboards, ganyan, or pag ng mga safety measures muna na hindi mahulugan yung mga dumadaan, hindi na comply yung nasa contractual obligations nyo, yung nasa contract nyo. Remember, your BDOS is also part of the contract. Okay? Meron tayong general conditions of the contract dyan. Meron tayong special conditions of the contract. You're not just bound with the contract na ilang pages lang, kundi kasama yung anong nasa bidding documents, kasi yun yung ina-assume nila ng obligation. So they are required to comply with that. Then assignment and subcontracting of the contract or any part thereof, or substitution of key personal name in the proposal without prior written approval by the PE. Ma'am, madi-delay kami dahil ang supplier namin ay hindi hindi na-ship yung ganito. Sabi nyo, subcontractor nyo yan? Oo. Bakit? Nag-agree ba kami na mag-subcontractor kayo? Ang delay ng subcontractor nyo ay delay nyo. Hindi po yan justifiable cost. Okay? Hindi justifiable cost na just because na-delay yung mga subcontractor nila ay delay din kayo. With or without your consent, pananagutan po nila pag may delay yan. No? So, or kaya nagpalit sila ng key personnel. No? Yung safety officer nila qualified sa pag-check nyo. Tapos yung safety officer nila nag-design, ang pinalit, hindi yan papasa kung yun lang ang pangalan na sinabit nila during bid opening at evaluation, hindi yun papasa sa inyo, pero yun na ang naging safety officer bigla. No? So that's without prior written approval on your part. So hindi din siya grounds for blacklisting din po yan. Okay? So another would be for the procurement of goods and satisfactory progress in the delivery of goods, no? Yung mga inihatid sa inyo, sira-sira. On the date of the deadline, yung inihatid sa inyo, hindi kulang-kulang or hindi siya nag-meet compliance sa quality. Kasi i-check nyo yan randomly. Diba? You are supposed to have an inspection team, especially in procurement of goods. Tapos, mali-mali yung mga na karating sa inyo. Okay lang po yan, kahit mali-mali, papalitan nilang ng tamang quantity at tamang quality ng goods kung malayo pa yung deadline. Kasi they still have until the certain period to comply, to meet their obligation, to perform their obligation. But if on the day of the deadline, saka sila nag-submit, tapos kulang-kulang, hindi nila ma-deliver lahat, hindi nila yung quality is low quality, hindi pumasa sa standards nyo, then that is considered as unsatisfactory. Consultant of the service arising from his fault or negligence. Now, is non-attendance or failure of the consultant to report to office considered poor performance? It depends. No? Kung nasa contract nyo na kailangan siya mag-report. Because remember, consultants are not your employees. This is quite a gray area, especially in LGUs. Some people thought that consultants are employees. Okay? No, they are not. Wala nga silang government service, diba? In fact, that is why it's most often abused, yung consultants na yan. Kasi mas walang yung mga prohibition on non-double compensation at saka yung lame duck, yung mga talunan na ginawang consultant, hindi masyadong na-check ng civil service. Although civil services, it's still covered. But still, laging nalalagay dyan yung mga lame duck. So, ang nangyayari niyan, ang consultants, akala nila empleyado. But no, consultants are supposed to be experts or highly technical experts on certain fields, and they are supposed to deliver a service or a product or a deliverable end product to you or deliverable service to you. No? Hindi po sa required mag-report daily unless you require them to do so. No? So dapat nasa contract doon kung may days at times silang mag-report. So yung iba mga consultant nyo dyan sa LGU na nag-report daily, dapat kasama yun sa contract because they are not supposed to. No? So, ngayon, considered ba yan as poor performance? No, unless it is there in the contract. Ang poor performance is kung kunyari, yung ina-assume niya is gagawa siya ng report. Yun yung consultant niya, gagawa siya ng ganitong, tutulong siya sa CLUP niyo. Tapos, dumating yung end ng contract na 6 months, hindi pa rin siya nakasubmit. Yung sa DRRM niyo, dumating yung mga design and build nyo, dumating yung end ng contract, wala siyang na-deliver. Hindi na nga nagpakita sa inyo, hindi na nga, tapos regular nyo namang binabayaran, nakikita nyo, wini-withdraw, tapos hindi pa naka-deliver, and that is considered a poor performance. They can be blacklisted. So that they will not victimize other government agencies na rin, no? For the procurement of infra projects, poor performance based on CEPES, no? You make use of your CEPES, no? Yung constructor's performance evaluation system rating sheet or existing performance monitoring system. Kung meron kayong sarili nyong performance monitoring system, pwede nyong gamitin din yan pag poor talaga yung performance niya. Kasi may criteria tayo, kailangan maging poor, di ba? Satisfactory or very satisfactory. Yun po yung gagamitin nyo. So grounds for blacklisting then, willful or deliberate abandonment or non-performance of the project or lawful. So yun nangyayari, naghanap na kayo ng ibang tatapos ng contract. Tapos fully bayad sila. No? Maki-question mo, bakit kaya binayaran? Truth is, nasusurprise din ako noon. No? So, it should be by progress payment yan eh. Bakit binayaran na hindi kumpleto ang project? Dapat progress payment yan based on their progress yung babayaran nyo. Hindi yung release kayo ng release, hindi nyo nga na-check. Wala ngang report yung project monitoring team na at least 80%, at least 90%. Yung slippage 30%, yung slippage 40%, pero yung bayad 100%. That is, oh my God, pati kayo, delikado kayo dyan. That is disadvantages to the government. You are not exercising highest standard of ethics, and there may be a presumption that you are corrupted. Okay, na-corrupt ba ang procuring entity? No? So yun yung maging presumption ng law. Then in case it's determined prima facie that the contractor has engaged before, ito yung sinasabi ko na it can go back even sa acts ng contractor during the time of procurement. Of the procurement activity. Yung nag-ano pa lang sila, bidding pa lang. In case it is determined prima facie that the contractor has engaged before or during implementation of the contract in unlawful deeds and behaviors relative to contract acquisition and implementation. So, depende na tayo as enumerated in the guidelines of termination of contracts. So, there may be times a contractor, no? May nakuha siyang contract sa inyo. Contract for the market. Tapos, yan, nakakuha siya, gumagawa na siya ng contract. Tapos may ginagawang annex na terminal building. Nag-bid din siya. In the terminal building, may na-commit siya. So, later na found out yun, although hindi na-award sa kanya yung terminal building, pero may ongoing contract siya. So, it will be, he will be handled hindi dun sa blacklisting during procurement, but blacklisting during contract implementation stage. Kahit yung contract na natanggap niya is iba doon sa actual na procurement na hindi na naka-violate siya. Pero pag ang unlawful act niya later was related to the contract na na-award sa kanya, dun po papasok yung guidelines on termination of contracts. Kasi nagsimula na yung project. No? So ano sa sanctions dito muna tayo sa blacklisting. Sanctions for blacklisting during contract implementation stage. Meron din tayong for feature, but this time around, it's for feature sa performance security na, not the bid security. Kasi wala nang bid security, na-expire na yon. Nag-post na sila ng performance security when they accepted the contract and signed the contract after the notice of award. No? So performance security for feature and then listing for 1 year or blacklisting for 2 years. Yun lang din po. Blacklisting pa rin. This is again without prejudice to the imposition of additional administrative sanctions as the internal rules of the agency may provide and or further prosecution. So ano po yung process? Next slide. May observe natin when it comes to blacklisting procedure during contract implementation stage. Okay. Blacklisting procedure during contract implementation stage is much shorter. 3 stages lang po siya. Okay? 1, upon termination of contract due to default or unlawful acts of the contractor, the hope shall issue within 7 calendar days a blacklisting order. Where contract termination is no longer possible but the contractor committed acts or causes which may constitute ground for blacklisting within 7 calendar days pa rin after lapse of project duration. So ang tatandaan po natin, 7 calendar days po yung i-issue yung blacklisting order upon termination of the contract. Pero yung procedures po niyan is, it starts with a notice of blacklisting. A notice of blacklisting is similar to a complaint filed for blacklisting. But this time around po, iba na yun siya. Wala na pong, hindi na po, dito matutuwa yung mga back members dito, hindi na po kayo involved dito. Bakit? This time around, ang magdedetermine po dyan is the implementing unit as a whole. So it could be that the procuring entity, the hope has assigned or specifically organized a project monitoring team, or yung implementing unit mismo. For example, the project is relating to the MSWDO, no? Or the DRRM. So sila yung implementing unit, no? So upon recommendation by the implementing unit, the hope shall initiate the blacklisting procedures by written notice to the contractor with the following information. A statement of the acts that constitutes the ground for blacklisting, an instruction to the contractor to show cause as to why it should not be blacklisted. Bakit hindi ka iba-blacklist? No? Special instructions of the procuring entity. Now, you ask questions. Ma'am, what if wala na po sila doon sa opisina? Paano po namin ipapadala yung written notice? How can we meet the requirement of sending a written notice? Remember, you're only bound to send notice to his address. Yung official address niya sa BDocs niya. It's not your obligation to search saan na ba tong taon na to. No? Wala po tayong by publication na written notice kasi hindi naman tayo korte na habulin ng summons yan by publication. Wala. That would be asking too much from you. Pag gagastuhin pa yung procuring entity, of course not. Yung written notice niya address dun sa official address na nasa BDocs niya. So the notice of blacklisting shall be accompanied by a copy of the verified report. Sino ang gagawa ng verified report? Is either the implementing unit or the project monitoring team kung merong ginawa ang procuring ang hope. So within 7 calendar days from receipt of the notice of blacklisting, the contractor shall submit the hope a verified position paper. Again, verified. There must be an affidavit of verification that the affiant knows, has read all the contents, at he has personal knowledge of his answer. Baka mamaya ang sumasagot na lang yan is si retainer lawyer kasi pala may kaso si client, affiant nagtatago na sa batas. No? So, yan. Pino-forge na. If the contractor fails to show cause after the lapse of 7-day period, either by inaction or by default, then the hope shall issue the blacklisting order automatically. Wala na pong suspension, okay? Yung suspension applicable lang po yan sa blacklisting procedure during procurement stage, but not during contract implementation stage. Pag hindi ka sumakot sa show cause order, after 7 calendar days, blacklisting order. The decision is within a non-extendable period of 10 calendar days from pag may sagot na verified position paper, non-extendable 10 calendar days naman, magde-decision si Hope. And it shall serve a written notice to the contractor's decision, which shall become final executory after the lapse of 7 calendar days from receipt of the notice of decision. Okay? So yun po yung ng contract implementation is. Kailan magpa-final yung blacklisting order? If wala pong MR on the decision to suspend, then maging final po siya within after the lapse of 7 calendar days counted from the receipt of the notice of decision. Okay. Pag walang sagot, automatically after 7 calendar days na walang sagot, blacklisting order. Pag sumagot, 10 calendar days for the hope to determine at to decide, and then 7 calendar days pag walang MR, issue na ng blacklisting order kasi final executory na yon. Now, if the bidder did not file an appeal din naman, MR niya, then again 7 calendar days counted para mag-file executory din yon. Na? If an appeal was filed, was denied, now what will happen if an appeal was filed and it was reversed? It means walang blacklisting. Tuloy ang kontrata, implementation ng contract. Or baka, nakasabi talaga siya na may justifiable cause. No? Like for example, lindol, sunog, wala na. Sira na lahat ng nasa stock niya na i-deliver sana niya. Kunyari, bukas na yung delivery, biglang lumindol. Nabasag lahat ng computers niya, i-deliver sana niya. That's a justifiable cause. No? So he has to procure again a certain number. Hindi naman kasi madaling mag-procure, na, especially if maramihan. Kaya sabihin natin, available lang naman yan off-the-shelf yung mga computers. Still, pag sobrang dami na pinoprocure nyo, direct to the supplier na sila. Kasi mahirap, hindi naman nagsistock sobra-sobra. Hindi naman tayo mag-procure sa SM. So, ano yung status of blacklisted person or entity uli? Next slide. Status of blacklisted person or entity. Ito yung ano ko na pag before issuance of blacklisting order, meaning balik tayo doon sa blacklisting during procurement stage, the hearing contractor may participate in the procurement of any government project except in the agency where he is suspended. Bakit? Kasi suspension pa lang siya, hindi pa siya blacklisted. Okay? So yun yung before issuance of blacklisting order. But the blacklisting order issued before notice of award during procurement stage pa rin. The blacklisted person entity shall not be qualified for award, and such project or contract shall be awarded to another bidder pursuant to RA 9184 and its IRR. Bakit? Kasi most of the grounds ng blacklisting during procurement stage are relating to unlawful acts din sa protest. Napansin nyo, yung mga grounds ng during procurement stage, same din siya. Similar din siya yung mga fraudulent acts, yung mga collusive acts. So it's a ground for protest. Hindi na i-award sa kanya yan kasi nga suspended na siya. Diba? Dapat nga i-didiretso na din yan sa suspension at blacklisting. So blacklisting order issued after NOAA, meaning during contract implementation stage. Pag may na-issue ng NOAA, notice of award, meaning during contract implementation stage na yan. So the awarded project contract shall not be prejudiced by the said order. Kasi baka yung nagawa ng contract, hindi yan matatouch, shall not be prejudiced, except where the offense is connected with the award or project or the contract. So if provided that the offense are not connected with the award, project, or contract, pag ang unlawful offense niya is connected dun sa contract na na-award sa kanya, we will go to the termination of contracts. Or if anong possible remedies. Kasi hindi pwedeng i-reward siya sa maling nagawa niya. Okay? So, application, we will go to that by detail later in penalty, penalty discussions. So, application of penalty, as I mentioned earlier, di ba, 1 year at 2 years tayo. Now, what if magsasapaw-sapawan na yan? Nagsapaw-sapaw na yung mga blacklisting order niya. So, remaining period of, pag first offense pa lang, remaining period of blacklisting order plus new 2-year blacklisting order. So yung 2-year blacklisting order later shall be deemed terminated and subsumed na siya. Subsumed. Now, if offense is more than 3, meaning 3 times na siya, kasi first or second yun, di ba? Yung first offense, second offense. Pag 3 times na yan, wala na pong subsumed. Full 2 years na po siya talaga. Na isi-serve niya yung mga additional penalties niya. Walang subsumed. So, next slide. Blacklisting order form. Ito po yung blacklisting order form. Please do not modify it kasi all the data that is required there, RD data is also required in the online blacklisting portal. So, kailangan kumpleto yung data para malagay na sa portal yung blacklisted entity nyo. Otherwise, pag may mga binabago-bago niya yan, pag binabago-bago niya yan, may mga kulang-kulang na data, madidelay yung blacklisting ng blacklisted entity, maka-bid pa yan sa ibang agency. Kasi wala pa daw siya day 1. O mabibiktima pa yung iba. So yung blacklisting order form, ito po nakalagay niyan, yung department office order or board resolution number nyo. Complete registered business name, address, and field chips registration number ng blacklisted person or entity, license number, applicable, for example, yung PCAP, for contractors, authorized managing officer. Sino yung amo nila? Kasi nagdadala ng managing officer. Name of project, contract, or location, amount. Specific grounds or offenses committed. Ano ang nagawa nila? Sanctions imposed on a specific duration, start or end. Ito very important tong number 7, yung start and end details. Kasi dito po mag-determine kung na-serve na nila yung blacklisting order nila o wala. Pag magkamali po tayo dyan, either mapapahamak, kawawa din naman yung negosyante, no? We intend to give them a lesson, not to punish them longer than what is necessary in accordance with the law. And date of issuance of the order to blacklist. Now, this is the online blacklisting portal. Next slide. The use of the online blacklisting portal, it is an online facility na developed by the GPPO, which allows procuring entities to issue blacklisting order. Dito po ipopost yung mga blacklisting order nyo. Update the status and access information related to agency blacklisting. Remember, once issue ng blacklisting order, forward nyo na yan sa GPPBTSO. But there is no prohibition, there is no limit for the aggrieved contractor to proceed directly to the court. Diba? Pwede pa silang mag-request ng court intervention. So, ang mangyari, kung makakuha sila ng any order in their favor, talagang kailangan nyo din yung online update, yung update nyo din yung status ng blacklisting. Kasi in case of lawful order from a judicial or quasi-judicial body directing the temporary or permanent lift the period of suspension or remove the name of a blacklisted entity from the consolidated blacklisting report, the entity through its official or alternate user, sino ang nagdadala ng portal nyo, shall immediately remove the name of the blacklisted entity upon receipt of the order. So, mapuputol yung blacklisted status niya pag makakuha siya ng mga lawful order in his favor. Pero later, upon final decision, nakita ng korte, ay talaga tama yung decision. Tutuloy ulit yan. Ibabalik niyo yan. Tutuloy na naman yung counting ng 2 years niya, no? So, blacklisting orders must be posted in the OBP, Office of, or on the online blacklisting order, 3 calendar days from the date of its effectivity. May period po dyan, okay? So, use of online blacklisting portal, upon lapse of temporary lifting order, kunyari, nakakuha lang siya ng 45 days, TRO. Tapos, hindi siya temporary TRO. Tapos, hindi siya nakakuha ng permanent injunction in his favor. Automatic, babalik yan. After 45 days, ibabalik niyo ulit yung pangalan niya, no? Repost ulit yung pangalan ng blacklisting entity sa OBP. Okay? You keep on updating. Whatever you receive na pwedeng maka-affect sa timeline ng penalty niya, i-update niya yan sa OBP. Okay? So, now, let's go to knowledge check. Tama lang tayo, 10 tayo natapos kasi meron pa tayong isang topic.
All right, at this juncture, we have our special knowledge check. That means that our participants should type in their answer in our Zoom chat box. So this is prize question po ulit. Meaning to say the first participant who will type in the correct answer following the right format of the name will win special token from GPPB. And the question is, when does blacklisting order become final and executory? Letter A, if the bidder did not file an AMR on the decision to suspend, Said decision becomes final and executory after the lapse of 7 days counted from the receipt of the notice of the decision. Letter B, if the bidder did not file a protest after his MR has been denied, the decision becomes final and executory after the lapse of 7 days counted from the receipt of the resolution on the motion for reconsideration. Letter C, if a protest was filed and the same was denied, the decision becomes final and executory upon receipt of by the agency and person entity concerned of the decision on the protest, or letter D, all of the above. Again, this question is a special knowledge check, meaning to say we encourage everyone to please type in your answer in our Zoom chat box. All right. Again, the question is, when does blacklisting order become final and executory? Again, hopefully guys, you read first or you comprehend first the choices before choosing your answer in our knowledge check. Again, letter A, if the bidder did not file a MR on the decision to suspend, said decision becomes final and executory after the lapse of 7 days counted from the receipt of the notice of the decision. Letter B, if the bidder did not file a protest after his MR has been denied, the decision becomes final and executory after the lapse of 7 days counted from receipt of the resolution on the motion for reconsideration. Letter D, if the protest was filed and the same was denied, the decision becomes final and executory upon receipt of the agency and person or entity concerned of the decision on the protest, or letter D, all of the above. Again, guys, please type in your answer. And we're going to end our special knowledge check in 10, 9, 8, 7, 6, and 5, 4, 3, 2, and 1. All right, let's browse our Zoom chat box. I believe most of our participants answered letter C. Some answered letter B, and it's just B and C actually. Well, on our poll, we still have percentage naman who registered their answer in our poll. We have 38% answered letter B, 25% answer letter C, and both A and B got 19%. Well, attorney, ano po ba ang sagot po sa ating knowledge check? Medyo scattered po yung answers po ng ating mga participants. We're going to unmute Attorney Aisa first. Yan.
So yeah, I think there was a confusion on the part of the participants because I discussed successively two remedial processes, no? Dalawang procedures to. It's about protest and it's about blacklisting. So yun, na-mix siguro sa mind nila lahat ng timelines, na-focus sila sa kailan maging final executory, not realizing that the question here is about blacklisting order. And so far, among the choices, yung A lang po ang nag-mention about blacklisting, yung decision to suspend. So blacklisting, remember, di ba, before blacklisting, meron pang suspension. Whereas yung protest po, it's a complaint against the bidding activity. Yung dalawa po, B and C are all about protest. Hindi po siya about blacklisting. Okay, so the answer po is letter A. It's quite catchy, you know? Like the bidder did not file. All of these actually are correct statements. All of those statements are correct. But the question is about the blacklisting order. When does it become final executory? Diba? While yung decision is suspension pa lang yan, after 7 calendar days, walang MR, saka pa lang yan, saka pa lang mag-i-issue si Hope ng blacklisting order. B and C are correct statements, but they are not the one we asked for. They are not the question. Okay, yun lang.
Alright, thank you po, attorney. Upon browsing po, verification and validation sa ating Zoom chat box, wala pong sumagot ng letter A.
Oh,
It's unfortunate, but we really need to move on. Since this is a prize knowledge check, we cannot consider any winners for this portion. So we're going to, I guess, have another prize knowledge check. If that will be granted or not on our next session. But again, guys, may I remind everyone to please comprehend, analyze the question first before choosing the answer, or more likely, listen carefully to our research speaker for better understanding of our subject. All right, let's continue po our discussion.
Actually, I think we're done already with our discussion. We'll proceed with the civil, penal, and administrative provisions. Tapos na po tayo sa blacklisting, and I think, yes, we already proceed to the next topic, the civil, penal, and administrative provisions. Session 7.
All right, I believe that ends the first learning session for today. So, Ma'am, can we have just a short break po muna? Just a short break before we proceed to our next session po. All right, again, thank you po, Attorney Aisa, for a very wonderful discussion of protest mechanisms and remedies and blacklisting guidelines. Again, we will be having a short bio break while you can have your things, your CR time or anything you want to do. Just be back here for a while. All right, I believe that was the very best bio break I ever encountered. At this moment po, can we now proceed to the open forum? All right, since we already prepared for the ABP for supposedly short break, we're going to have again our short break. All right, we'll be back after a short while.
Okay.
Do you know that procurement is crucial in achieving our society's collective vision of a strongly rooted, comfortable, and secure life in the Philippines? Hello everyone, I'm Billy Bayong. Let me show you how our Procurement Policy Board innovates, adapts, and responds to our changing needs to enhance the procurement system and help the government work for us. An efficient, transparent, and competitive procurement system connects every Filipino to vital services from the government. This can help move more people out of poverty, gain access to better education, receive quality healthcare, and enjoy economic opportunities. These yield greater trust in government institutions and bring the country closer to achieving its national development goals. The Government Procurement Policy Board focuses on simplifying various processes to produce more successful procurement that contributes to the effectiveness and efficiency of the government. The board employs strategies to identify needs and implement projects. It refines and calibrates procurement policies, adjusting to emerging trend based on needs of procuring entities. It creates ways to capacitate practitioners to better manage their procurement processes, monitor effectiveness of our procurement systems, and it adapts to the times, especially during national emergencies. The GPPB has strengthened the procurement process at the earliest stage, the planning phase. The board has issued bidding rules responsive to new laws and policies set by the government. GPPB has also streamlined the bidding process through the use of technology. GPPB has introduced guidelines to ensure timely procurement, especially during a national emergency. GPPB Technical Support Office pioneered initiatives to better assist procuring entities. Simple and competitive, transparent and accountable, monitored by the people. These make for an effective procurement system, responsive to the needs of the people. The GPPB, adapting, responding, innovating for nation building. To know more about procurement, visit gppb.gov.ph.
All right, I hope everyone is back. And now we're going to proceed with our first open forum. All right, again, may I invite our research speaker, Attorney Aiza?
Yes, I'm
Hello
here.
po. Again, questions are initially gathered from Zoom chat box and Facebook, YouTube, and due to live streaming comment sections are filtered as our research speaker shall only be answering questions related to our first learning session. All right, can we po okay, let's start with our first question na po.
Sige. Can you just read it for me because
We will flash the question. Ayan po. Okay, you're right. Is it correct to process the payment without the signature of the acceptance by the GSO in the inspection and acceptance report? What kind of penalty will be imposed on the concerned personnel?
is it correct? Sandali, sasagutin ko muna si Miss Jo. May si Miss Jo dito. Okay po. Okay. Ito na. Is it correct to process the payment without the signature and acceptance by the GSO in the inspection acceptance report? What kind of penalty will be imposed on the concerned person? Kasi kasama po yan sa i-attach nyo sa DP nyo, yung inspection acceptance report, di ba? Sa internal audit nyo, ewan ko paano pumasayan na ipaprocess nyo yung payment without the inspection acceptance report. How sure are you that it is delivered? The one that you procured is the one that is being delivered, or that it is acceptable quality and quantity? So yes, it is required that there is a signature by the hindi naman necessarily GSO, but whoever is authorized by the procuring entity to inspect and accept.
All right, thank you po. For our next question.
What kind of penalty? I may isa pa pala siyang question. What kind of penalty? Hindi pa po niya determine po kung may administrative liability siya or wala. Kasi right now, kung wala namang nawala sa gobyerno at kung wala namang proof of nag-process, di ba? I mean, you could be wrong also, na mali lang yung pag-guide. To ask what kind of penalty, I think it's premature. Next question.
All right, next question po. For our next question, Is there a liability on the part of the procuring entity if they did not impose liquidated damages or blacklisting to an erring contractor? For example, the project was not completed as per project duration period without any valid reason and they did not request for any contract extension.
Alam mo, lagi itong tanong eh. Kasi di ba ang nakalagay lang doon that in case of failure, the erring contractor is required to pay liquidated damages, no, or undergo blacklisting. Pero wala daw nakalagay na penalty on the part of the procuring entity, administrative sanction if they will not pursue a blacklisting action or impose liquidated damages. But the mere fact that the law requires such, tapos hindi nyo ini-impose yun, o hindi nyo pinapasa blacklisting, it's already a misfeasance on your part, diba? Misfeasance on your part. Kasi you're a government officer, and this liquidated damages and blacklisting action is meant to protect the interests of the government. Not only you, but also other government agencies. So if you fail to blacklist a person that is habitually committing unlawful acts, or you are exposing other government agencies, no, to this kind of contractors or bidders. Now, if you do not impose liquidated damages, it means the government incurred losses and you did not protect the interests of the government. So remember, you are not only punishable under RA 9184, but you are also punishable under RA 6713, RA 3019, and other revised penal code on felonies, crimes committed by public officers. So you could be charged with those crimes there, felonies there. So the project was na sample lang pala. Yes.
All right, thank you po. For our next question po. In the event na nag-file ang bidder ng request for reconsideration to the BAC, then the BAC take action or resolution beyond the prescribed period of 7 calendar days, administratively or criminally liable ba si BAC?
Ang strict naman yan. Actually, we presume that the BAC will just finish it within 7 calendar days because that is too much time already. But if in case, hindi naman criminally liable, but yeah, they can be charged administratively liable for RA, again, sa RA 6713. Kasi RA 9184 did not anticipate na hindi yan ipa-follow ni BAC yung period, okay? May mga instances tayo na yung batas hindi na nag-anticipate na yung mga maliliit na bagay hindi pa masunod. Kaya doon na lang po yan papasok sa ibang laws, penalizing for your inaction or failure to act within the prescribed period of time. So since the prescribed period of time is 7 calendar days, you can be administratively sued there, no? So, yeah, careful din, no? Baka may iba nga talagang pati bagay-bagay na yan, yun talaga kayo. Just decide. Anyway, it's just a request for consideration. You can decide on that and then it will go to the hope anyway. Huwag nyo na lang patagalin.
All right, thank you po. For our next question, I believe that was the last question po for our first learning session about protest mechanism and remedies and blacklisting guidelines. All right, without further ado, let's now proceed po on our last learning session or learning session number 7, which we will going to tackle about penal, civil, and administrative provision. Without further ado, let's all welcome again our research speaker, Attorney Isa Fiel Nogra.
Thank you. And this time, I'm glad na sa share content, nakikita ko na finally ko ano ang sinushow sa inyo. Kanina, I was frustrated because I cannot see anything. I was just hoping na nagmamatch yung pinagsasabi ko sa pinagsusunod dyan. So finally, I asked also Ms. Bislik earlier because there seems to be in the slide here, kasama pala yung contract termination because in my previous talks, hindi nila sinama. So I'm glad din kasi dati talaga minamadali ko lang talaga ipasok yung contract termination. Kasi in administrative proceedings, in penal proceedings, natatanong din kasi talaga ng mga participants. So, dahil hindi kinakat nila yung mga slides, yung sa last 2 weeks ko, na presentation, kinakat ng GPPB yung slides, saka sinahabol ko lang, verbal lang. Ito at least kasama, no? So, now we will discuss civil, penal, and administrative provisions. While earlier, those are remedies, no? Sana hindi ma-confuse yung mind nyo sa protest, sa blacklisting, at ito naman civil, penal, administrative provisions. As I mentioned earlier, these are remedies, these are mechanisms. Maraming instances na feeling nyo, pare-pareho lang yung mga grounds. Kaya nalilito kayo kung saan na ba ito napasok, sa protest na ba ito, sa blacklisting na ba ito, o sa civil, penal, administrative provisions na ba ito. Hindi po siya, medyo may mga similarities and grounds because an unlawful act will always be an unlawful act, whatever side you will look at it, especially those intended actually to defraud, to corrupt, to coerce. Yun talaga yung mga unlawful act, hindi siya ano lang. So remember, protest is related to procurement activity, whereas blacklisting is related to the behavior of a particular contractor or bidder, no? While yung protest naman sa manner ng pagkandak ng procurement, yung blacklisting sa mga pinaggagawa ng isang aggrieved contractor. Now, we go to civil, penal, administrative provisions this time around. Kasama na po kayo dito. Okay? Be careful because when it comes to civil, penal, administrative provisions, not only the private entities can be subjected to these provisions, the penalty under these provisions, but also us, no, public officers. Not only public officers who are involved with the Bids and Awards Committee, not only public officers who are involved as whole, or TWG or Back Secretariat, depende sa involvement nila, kundi lahat ng public officers na nakikisali. Kaya be careful if you have husbands or wives who are in other government agencies na kumbaga, siguro gusto din malaman ko, ano mo pinagagawa niyo, meron daw kayong ganito na big ganyan. Uy, ito, ganyan. Be careful with those kind of actions because some of them can be borderline prohibited. Okay, so let's start with the standard of ethics. Bakit kailangan iset natin agad ang standard of ethics? Because this involves public procurement. And when you say public procurement, it involves public money. Public money which is entrusted to us as public officer, and public officer is a public office, is a public trust. So, public office is a public trust. We are required to show the highest standards of ethics. Not only, wag na lang nating sabihin, alam ko naman sa loob na loob ko malinis ang aking kalooban. Not only that, it's not enough. Dapat pinapakita nyo din yung standard ng ethics na ine-exercise nyo. Hindi lang yung alam nyo sa sarili nyo na wala kayong ginawang masama, kundi dapat walang kaduda-duda na sa paningin ng iba, wala talaga kayong ginawang masama. Okay? That's the highest standard of ethics that we require. Required to be observed by not only the procuring entities and bidders, manufacturers, suppliers, and distributors during the procurement and execution of a contract. Lahat ng gusto ma-involve sa public procurement, ma-opisyal ka ng gobyerno o manegosyante ka, kasama ka sa mag-observe ng standard of ethics na ito. So the bidders determined to have committed corrupt, fraudulent, collusive, and coercive practices by the government will not be eligible to bid in its projects. So para na rin siyang blacklisted, no? So blacklisting is part of the administrative provisions. Kaya nga nagulat ako kanina na yung protest at blacklisting nauna kasi supposedly it starts from civil penal tapos diretso tayo sa administrative provisions. But since that was the case, ito, i-remind ko ulit kayo. When bidders will not commit corrupt, fraudulent, collusive, and coercive practices like yung mga enumerate natin kanina, na grounds for blacklisting, then they will not be eligible to bid in its projects by being suspended and by being blacklisted afterwards. Now, not only that, sabi mo, 1 year, 2 years lang naman. The problem is, in RA 9184 and even RA 3019, there is also civil and penal aspect. No? Especially sa penal aspect. Mas kung 1 year and 2 years lang yung blacklisting at suspension, mas mahaba po sa mga disqualifications under penal. So that's why we will start with penal later. Standard of ethics. Ano ang mga acts na dapat nating i-avoid in order to avoid the standard of ethics? Next slide. Okay. Ito na-enumerate ko kanina yung iba't ibang acts. But you can actually summarize this into 4. Coercive practice. Coercive, from the word coerce, may pamimilit. Pwede ding may pananakot. Diba? Panggigimbal, katakot-takot. Ganon. May panghudlat kung sa ato pa sa Bisaya. Okay? So, yan po yung mga times na may mga even us, government officers, tinatakot tayo. Sasabihin niya, yung anak mo, jowa yan ng anak ko, may mga nude pictures. O di ba tinatakot ka? O, kasama po yan sa mga coercive practice na, yung ipaparape ko yung anak mo, ipapatay ko yung asawa mo, or yung sisirain ko yung, hindi na kayo ng mga negosyo dito, hindi maka-operate na negosyo natin. That's kasama ng mga coercive practice. Collusive practice, ano naman po yung collusive practice? From the word collusion. When you collude, there is an agreement. There is a scheme. There is an arrangement na nagsabuatan kayo. Bakit sabi niya? Negosyo naman yan, ma'am. Hindi ba pwede na kanya muna ngayon, ako na muna bukas, ganyan. Actually, kasi, di ba, we have in the principles of procurement, competition. The spirit of competition must not be undermined. Pag may collusion na nangyayari, talo ang gobyerno. Okay? Bakit natin sinasabi ito, talo ang gobyerno, ma'am? Ayaw nyo nun, may bidder kayo ngayon, may bidder kayo bukas, may bidder kayo para doon. Kasi po, ang interest ng gobyerno is to make sure that meron tayong makukuha na value for money in our projects. Hindi yung isa lang yung choice natin. For the quality that we expect, na nilagay namin sa text specs namin, sa program offers namin, is the quality that we expect, makakuha kami ng best price in the market. Hindi yung isa na lang ang pagpipilian namin kasi tinatakot at nyo na lahat. Or kaya, nagkasabuhatan na kayo lahat. So that is anti-competition. Okay? Then next would be corrupt practices. Etong corrupt naman, maraming, it could be in money or in kind. Pwedeng tumatanggap, may bribery, which is another punishable act under revised penal code, or maybe rin in kind. May mga nakukuha kayong benefits. Either, sabi nga nila, kung ano daw yung tiles ng barangay hall, yun din yung tiles sa bahay ni Kap. Diba? Or kaya, empleyado, yung anak mo, sure ball na makapasok sa ibang negosyo ni contractor, di ba? So, yun yung mga corrupt. It could be in kind or in money. Then, kasi nakukorrupt kayo na mayroong gain or benefit kayo na ini-expect. Okay? Pag may gain or benefit na ini-expect on your part, that is a corrupt practice. Then, fraudulent practice. Ito naman yung misrepresentation. May balak kayong lokohin, may balak yung contractor or kayo, kung may sabuatan on your part, na lokohin ang gobyerno. Na mag-appear kayo that you are eligible, that you have this kind of expertise, that you have this kind of credibility on your last projects, reliable kayo na contractor, tapos yun pala, you are misrepresenting yourself. You are using other entities' license. You are falsifying some documents, no? So, that is a fraudulent practice and that is an unlawful act. So, ano po ang pwedeng, with all these acts, remember that in our laws, one act could give rise to 3 liabilities, no? Meron yung 3 pong yan eh. 1 right could give penal. That is the criminal part. Penal is criminal. Second would be the civil aspect. Yan yung involved na pagbabayarin kayo. May mga fines. Or may mga forfeiture. Then, administrative. Of course, yung administrative kasama na yun na yung blacklisting. No? So, ano ang mangyayari sa penal provisions? This one is more mabigat. Kaya nga, blacklisting is mandatory, pero ito talagang penal, you have to forward that to the courts. Yung blacklisting, kayo, ang procuring entity, ang mag-handle niyan. But on the criminal and sometimes I would say criminal, but it's the same with penal. But on the criminal and the civil aspect, it is always the courts. Hindi hands-off na po kayo as procuring entity. Why? Because there can be tendency to hide your involvement. May tendency ang mga procuring entity, ipo-blacklist na yan tapos hindi na ipo-forward for a criminal action. Bakit? Kasi baka nga naman may masilip ang court, may masilip si ombudsman, no? Na criminal liability din sa part ng ilang kasama sa procuring entity. So this one is pupunta talaga ito. After ng blacklisting nyo, pupunta yan talaga sa courts. Okay? So, coverage ng penal provisions. We will start with the penal provisions. This one is, sabi ko nga, mas mabigat. Because this is without prejudice to the provisions of Republic Act number 3019, otherwise known as the Anti-Graft and Corrupt Practices Act, and other penal laws. In fact, I have also encountered some decisions of the Supreme Court na not only yung RA 3019, kundi RA 9184. Talagang multiple talagang sinasite nila. No? So yung pinakamabigat na lang ng penalty ang ini-impose. So coverage of this. Sorry, minsan unmute ko kasi nga nasa bahay ako. Uphill kasi itong bahay namin. So anyway, so sino po ang covered ng RA 9184 na criminal provisions? Both public officers and private individuals are covered by the provisions of RA 9184. Kung yung blacklisting po na administrative provision, you initiate it against contractors committing unlawful acts lang. Ito pong innovation, tama po tayo, rated under Section 65.1 of the IRR, mamaya makikita niyo yun. And the private individuals who collude within. Sino ba yung mga private individuals na yan na nakikipagsabuatan sa inyo? Okay? Kaya ingat-ingat yung mga parientes natin na nakikisali, ano? Kasi mamaya si asawa, nakikisali kasi boss niya, nagpapasikat doon sa boss niya. Nagbo-broker pala. Ayun. So, pwede po silang makasuhan. Private individuals who commit any of the acts din naman enumerated under Section 65.2 and 65.3 of the IRR, again, mamaya enumerate natin yan, and public officer who conspire to them. Kunyari, yung sa collusion, alam nyo na, kayo pa naghanap ng, kayo pa nagsuggest, kayo pa nagbo-broker para mag-usap-usap sila at magbigayan. Kaya kasama din ang public officers na nag-arrange, no, na mapagtagumpayan, maging successful yung mga pagginagawa ng mga private individuals. No, that is against the law. So it should cover, next slide, all types of procurement, whether done manually or electronically. In some agencies, they already have electronic bidding. No? Even those who are submitting their bids online, yun. Kasama na po yan. Hindi po yung manual lang na nagdadala kayo ng envelopes nyo. Yun lang ang punishable. In fact, some people also, I wish mas dagdag din ito, no? Some people are even asking me, Ma'am, kaya gusto namin na alternative modes na lang kasi mas mahirap sa may bidding kasi mas stricto, mas magkamali kami, makulong kami. No, actually it covers all types of procurement nga. Kasama yun whether alternative modes ang ginagamit nyo or competitive bidding. Diba? So kung may mga ginagawa kayo, nagli-leak kayo, binubuksan nyo yung mga sinasubmit or nagsasabi kasi ba, uy, ito yung offer sa kabila. That's still part pag mahuli kayo, no? So not only manually or electronically, but even those with bid or without bid. No, any amount. Sabihin nyo, ma'am, maliit lang naman na amount. Kasama pa rin yun kasi cover all types of procurement nga. Kahit ngayon below 50,000, kasama yun. Pag may ma-discover na mga ginagawang anomalya kayo, or sila, no? So when the bidder is a juridical entity, criminal liability and excessive penalty shall be imposed on its directors, officers, or employees who actually commit any of the following acts. Sabi ko nga kanina, there are two kinds of persons, natural and juridical. Madaling i-punish, madaling ikulong yung natural. Siyempre, may warrant of arrest yan, aarestuhin yan, ikukulong, himas rehas. Pero pag korporasyon yan, sino ang mananagot? Kung mga partnership yan, sino mananagot? The people, the real people behind those juridical entities. Yung juridical entities, hindi mo naman makukulong yung Ayala Corporation at SM Corporation. Ang ikukulong nyo po, yung mga tao sa likod na yan, those who make the decision. So, depende yan. Sino yung may controlling interest ng shares, sino yung kasama sa management, sino yung CEO, o yung employees, kahit employees na staff, pero they actually commit any of the following acts. Sila mismo yung tumatakbo-takbo. Sabi na, utusan lang, aware ka, bawal yan. Kaya, nag-deliver ka ng pera, aware ka, bawal yan. Diba? Ikaw yung tagadala, bagman, aware ka, bawal yan. Hindi pwede sabihin inuutos lang sa'yo. Yan yung problem kasi under special laws, these are special laws, no? Under special laws are like RA3019, RA9184, your good faith is not a defense. Unlike revised penal code where good faith is a defense, sa special penal laws po hindi. Kaya wala pong good faith dyan. So coverage, next slide. If a person previously held liable or found guilty under the provisions of the Act and this IRR has controlling interest, ito yung naman sabi ko, extension, di ba? Kanino extended yung disqualification to participate in any government procurement activity? Sino yung may controlling interest? Kahit may iba siyang negosyo, damay po yun. Kasi may controlling interest siya dun sa juridical entity or corporation or partnership na blacklist. So, pati asawa, damay, di ba? Yung sa mga sole entrepreneurs. So, applicable penalty po under the penal, ano po yung mga penalty pag you're found criminally liable under RA 9184. Next slide. Ito masakit po to. Imprisonment for not less than, next slide po, imprisonment for not less than 6 years and 1 day, but not more than 15 years. Ito yung sinasabi, lumampas po. Ayan, yan, tama yan. Imprisonment for not less than 6 years and 1 day. Ito po talaga, specific yung RA 9184. Ano yung penalty? Kasi kung hindi po niya i-specify, baka po hindi maagdag back in law. You will remember that 6 years and 1 day is not probationary. Okay? Hindi po siya pwede mag-apply ng probation pag ang penalty mo ay 6 years and 1 day. Ang pwede na mag-apply ng probation, meaning mababaan yung actual time mo talaga na nasa kulungan ka, is yung 6 years below. Okay? Yung 1 day na yan will make a difference kung makakalabas ka early or hindi. 6 years and 1 day but not more than 15 years. So, yan po yung imprisonment na naghihintay if you commit any of the following acts we will enumerate later. And ito, mas mahaba-haba pa ito sa blacklisting. Penalty of temporary or perpetual disqualification for a public officer and permanent disqualification from transacting business with the government, private individual. So yung private individual, permanent disqualification na po siya. Say, yung public officer naman, temporary or perpetual disqualification. But be careful. Even if ang sabi dito is temporary or perpetual disqualification, but in RA 3019, if you compare it, it's actually perpetual disqualification. So, kaya ingat pa rin tayo kung saan tayo, baka dyan tayo sa RA 3019. Kung dito naman sa RA 9184, at least, merong chance tayo sa temporary disqualification, makakabalik pa tayo, no? Yan po sa mga public officers. Dito sa permanent disqualification, marami ako napansin, ang lalaki na contractors, bakit hindi kayo mag-bid sa amin? Wala ma'am, ayaw naman sa gobyerno, hirap magbayad, ganun. No, may kayong big project sa government. Diba? Yun nga, sabi ng iba naman sa PIC, nag-ate, no, sabi na, disqualified yan ma'am kasi ganito yung ginawa nila last time. Okay. So yun, talagang nakakabawas yun sa income, no, opportunities. Then jurisdiction, next slide. Jurisdiction over the offenses defined under this rule shall belong to appropriate courts. As I mentioned earlier, only courts can impose penal sanction. Hindi po kayo. Limited lang po yung procuring entity sa administrative sanction, administrative provisions. Only the courts can impose penal sanction and the civil penalties na accessory din kasama dito. So, according to laws existing at the time of the commission of the offense. At ito nilagay lang itong according to laws kasi dati kasi may mga kaso na hanggang RTC lang. But right now, the MTCs are expanding their jurisdiction and depending din sa amount mo. But right now, it's still mostly RTC talaga. So next slide. Offenses committed. So ano po ba yung dapat naming iwasan para hindi naman kami makabisita sa mabaho at mapanghing CR na presuhan na yan? No? Kasi 'di ba, ganda-ganda natin sa office natin, naka-lipstick pa tayo tapos doon lang tayo malalagay. Hindi naman tayo nag-apply para maging back member. Ina-appoint lang tayo. Ayaw naman sana natin. Pero andun na. So, by public officers, what are the acts that can be committed? Ito, opening any sealed bid. Huwag masyadong curious at marites. Uunahan mo yung opening of bids. Open any sealed bids, including but not limited to the bids that may have been submitted through the electronic system. Huwag maunang buksan. In fact, under revised penal code, that is also punishable, no? Infidelity of public documents, no? Sa crimes committed by public officers. So, pwede din kayong doon mademanda. Pwede din dito. At least dito, mas malaki-laki yung penalty, no? Yan ang pipiliin ng mga kalaban nyo na gusto magdemanda sa inyo. Or ni aggrieved bidder na feeling niya inililik mo magkano yung bid niya, bid offer niya. Then delaying with, kasi reality no, maybe sa inyo sa LGU, di ba wala na tayong geographical limitations when it comes to bidders. Even bidders from Basilan, from Tagigaraw, can now bid in Negros, in Catbalogan, in Cagayan. They can already submit their bids and they can do it electronically. They will have to have, there has to be a provision in the law that will make them trust the system. So, kaya marami ang bawal sa part natin. We have to exercise highest standard of ethics. Then, delaying without justifiable cause, screening for eligibility. Ito lahat. Screening for eligibility, opening of bids, evaluation, and cost. Ito lahat mga procurement activities. So, any delay in the procurement activity without justifiable cause, that is punishable by law criminally. No? So, dapat with justifiable cause lang. Like for example, lumilindol sa Abra. No? That is what if at that time they were scheduled to open bid. May isang barangay doon na scheduled sila to open the bid. Tapos, andun na sila sa loob, biglang lumindol. Naglabasan sila. No? So, hindi na nila matuloy kasi they cannot enter the barangay hall structure until it is being inspected as safe. So, may mga delays talaga na justifiable din. Then, unduly influencing or exerting undue pressure on any member of the BAC or any officer employee of the procuring entity. Ito ang sinasabi ko na delikado pag nakikisali ka sa mga procurement activities ng ibang procuring entity. For example, kaibigan ni Mayor na administrator ng ibang municipality, magkaibigan sa kasi dating mayor din yun. Mayor, yan, kaibigan ko yan, mabait na tao yan. Tapos, pare, iba yung na lowest calculated and responsive bid na nirecommend ng BAC. Pare, hindi ba pwedeng pag-usapan natin yan? Kasi ganyan, pwede naman. Ganyan. Nangingi alam. So, do you think it's only the hope na mapipersuade ang pwedeng maireklamo? No. Not only those public officers who belong to the procuring entity, but also any other public officers who got themselves involved by exerting undue pressure or unduly influencing any member of the BAC or any officer employee of the procuring entity. Okay? So, kasama sa, yun na nga, hindi na nga sa kasali, sumasali pilit. Kaya yun, pwede mangyayabot. Kaya when you have procurement activities in your agencies, do not talk about it so much sa mga family nyo. Kasi baka ma-excited masyado magkwento sa di ba? Or especially kung nasa ibang agency, tapos malalapit sila sa Meron din lang, do you deal with the same kind of projects or contractors? So, iwas na lang natin pag-usapan yung trabaho sa bahay. So, another offense that can be committed, ito laging tanong. Next slide, splitting of contracts. Always remember, splitting of contracts is only punishable or you can only be liable if you intended the splitting of the contract to avoid competitive bidding. So there will be times you will be, hindi naman siya splitting of contracts na intended for to avoid competitive bidding, but only you think that there will be more takers if ilat-lat natin. Or we can afford it better if i-by phase natin, di ba? Either you intend to implement a project by phase or you intend para matapos nyo talaga kasi kulang-kulang kayo sa budget. Kasi not everyone naman has big budget, di ba? We are classified into different classes. Yung mga municipalities and some have big money, some don't have enough money, but we all have the same dreams. Pareho naman tayo ng pangarap. Tapos pareho pang nire-require ng batas na kailangan meron tayong ganito, meron ganyan, di ba? Ang daming laws na sobrang marami nire-require sa inyo, but you cannot afford it yet? Or dahil ito lang yung law na ginagrant sa inyo ng DBP or land bank? So it's alright if you can implement it by phase kung tama lang naman. Or if mga goods naman, i-implement nyo by lots because let's be honest, not everyone who can supply you with steel cabinets can supply you also with computers, or not everyone who can supply you with computers can supply you with photocopiers, right? So, pwede nyo ilat-lat yan to make sure that there are takers at hindi kayo magpe-failure of bidding. For as long as the reason of splitting a contract is not to avoid competitive bidding. Now, if you purposely split the contract para mag-alternative modes of procurement kayo, para hindi na kayo mag-bidding kasi sabi nga, ang hirap ng competitive bidding. Maraming ayaw ganon. Yun yung maging problem. Sa bagay, ako naman nakikita ko sa MLGUs naman kasi sa municipalities, you have very low threshold when it comes to alternative mode of procurement, no? Hindi kayo masyadong mabibiktima dito, magbibidding talaga kayo. So that is not, hindi kayo masyadong mapupfall dito kung nagbibidding naman kayo, no? Kahit in-split-split yan, pero nagbibidding kayo, intended nyo lang para masiguradong hindi mag-fail yung contract. Tama na, okay lang. No. So MLGUs, you have very low threshold when it comes to alternative mode of procurement. You just bid most of your projects. It's actually, I have to be honest, it's actually NGAs who would fall victim to that. Kasi sobrang laki ng threshold namin, tigwa 1 million. No? Kaya ayaw na bidding. Pinipilit mo talaga. Magbibidding tayo kasi kailangan to ibibidding. Ganun. Hindi natin ma-justify. So also, public officers, remember Section 41, the head of agency has the power to reject any and all bids, right? If he deems that it's not anymore practicable or not more convenient or may mga hindi nasunod sa procurement guidelines, procurement rules, pwede niyo pong i-reject any and all bids, no? Tapos mag-bid kayo ulit. But if there seems to be an abuse, lahat na lang nire-reject niya. Ayaw na, bakit? Kasi hindi si friend niya yung nanalong lowest calculated and responsive bid, then he can be penally liable. Okay? Kasi abuse na po yan. Yung hindi talaga justified, nakaka-delay na kasi. Kayo din ang laging ulit-ulit na lang kayo, hindi pa rin satisfied. Tapos, after second failure of bidding, mag-negotiate. Tapos, pag negotiate yung kaibigan, papasok na. Diba? So, yan. Pag lagi niyang ginagawa yan, pwede po siya maging criminally liable. So, how about private individuals naman po under Section 65? Ano naman po ang mga offenses that can be committed? Some of these offenses that can be committed are the ones I mentioned earlier already sa blacklisting, no, during procurement stage. So next slide. Agreement and submission to submit bids with prearranged lowest bid. May usapan sino na ang lowest bid, no? Ikaw muna ngayon, kunyari lang tayo. Sabihin ni Mayor, bid kayo, kendot ko ha? Ikaw ngayon, ikaw ang lowest. Wow. Yung mga ganun, pwede not only si private individual na may usapan, pati si public officer who conspire are also liable under this provision. O kaya si Black Secretariat, ayaw niya kasi paulit-ulit, ma'am, maraming trabaho pag nag-fail, kaya sinisiguro ko lang. No, no, no. Don't do that. Then malicious submission of different bids through two or more persons. Hindi siya sigurado kung yung bid niya ang lowest. Kaya nagsubmit siya din ng iba pang bid, ng dalawa pang bid through two or more persons. Sabi nga, more entry, more chances of winning daw. Kaya dami siyang personality, dami siyang pinasubmit, siya lang din lahat. No? Agreement to secure undue advantage. Ito naman, again, ito yung sa collusion. Pasok pa rin sa collusion. Undue advantage, it means it's disadvantages to the government. Diba? Kasi sila yung naka-advantage. May presumption that it is disadvantageous to the public. Employment of scheme, disadvantageous to the public. Pasok pa rin po sa collusion. Now, let's go to other offenses pa ng private individuals. When two or more bidders agree and submit different bids as if they were bona fide, when they know that one or more of them was so much higher than the other. Ito yung usapang atin-atin, no, kumpare. Ikaw muna, pare. Ako naman dito ngayon. Sige, bibigay ko itong isang contract na to. Tapos doon, wag ka na mag-bid doon, ha. Sige, pare, basta makuha ko lang itong contract na to para mahabol ko sa eligibility requirement ko para sa isang contract na gusto ko din kunin. You know why they do that? It's because they also have, may mga targets din kasi sila ng mga bidding opportunities na gusto nilang pasukan. Tapos hindi sila magka-qualify, kaya they have to take more projects na which will help them qualify in other bidding opportunities. Kaya doon pumapasok yung mga usapan, bigayan, especially classmate din sila sa engineering school. So when two or more bidders and to an agreement. Next slide. Which oras ng gobyerno, nag-withdraw lang naman pala. Or maliciously submits different bids. Ito mga same lang talaga to. May mga fraudulent acts. Okay, may mga fraudulent acts sila. In connivance with others, either public officers or private individuals. Okay, to restrain competition, to stifle competition. All these fraudulent acts are presumed to be advantageous to them and disadvantageous to the public. We're not advocating naman na malulugi yung mga businessmen who in good faith allowed us to procure the things that we need. But hindi pwede ding mailagay sa alanganin ang gobyerno na para na lang tayong pinagaluan. Overpriced na lahat, di ba? Ang daming maririnig nyo sa TV ng mga overpriced products, ganun. Somehow you question, where did it go wrong along the way? Sasabihin, yung mo pumirma. Lagi naman talaga yung hope at yung back ang nasisisi. But the truth is, it involves the entire procuring entity. Yung PMO pa lang, yung mga implementing unit na naghingi niyan. Sila ang nagde-determine sa ano ang bibilhin, magkano ang bibilhin, ano ang specs. Tapos kayo naman pumapayag. Yun doon naman magsisimula. Kaya nga pre-procurement activity is very important. Also, your APP is very important. Planning is very important in general. Kasi doon yun magsisimula. Kaya lalaruan kayo ng mga bidders kung nakikita nilang kulang kayo sa planning. Hindi nyo nga alam kung ano ang ang mga bagong technologies na gusto nyo procure, hindi nyo nga alam kung magkano ang ongoing market price na mga gusto nyo i-procure. Basta lang kayo nag-guess ng mga amounts. Tawang-tawa yung mga yung mga bidders kasi ang laki pala ng price nyo, bloated. Anyway, so yun po yung mga acts na submission of eligibility requirements, containing false information. Next slide pa din. Using name of another, allowing another's name. Withdrawal of bids, submission of bidding documents containing false information. Next slide po. Actually, these were the same offenses na enumerate natin kanina sa blacklisting, grounds for blacklisting. Okay? So, yeah, if you look at it, they're all the same. So, maka-classify nyo lahat ng mga acts na yan, either public officers or private individuals, into collusive, mga usapan, arrangement, or scheme, corrupt practices, may mga gains or benefits on your part, on their part. Coercive, may mga pananakot at pamimilit, or yung mga abusive, no? Coercive, collusive, corrupt, at fraudulent misrepresentation. Hindi sila gumagamit sila ng ibang eligibility documents, no? So, yan po yung mga grounds ng penal. Pwede po silang makulong. Wag kong sabihin, hindi ko dapat sabihin pwede kayo. Kasi I will presume that from here, you will learn and it will never happen to you. Although there's many instances that I have participants who are already facing cases. No? Andun pa rin sila kahit hindi na sila part ng back kasi suspended pa sila pero pinapasali sila ng hope nila o ng bagong head nila sa seminar para at least maintindihan din nila kung in case man mag-swelto sila. Sige. Okay, I think we'll go to the knowledge check first before we go to civil liability.
All right. I believe we are now on our first knowledge check for our second topic, and since wala pong nakatama dun po sa special knowledge check kanina nga po sa una po nating topic ay this will be considered another chance to you guys to redeem yourself because this is another prize knowledge check. Again, may I request everyone to please type in your answer in our Zoom chat box, and the first one with correct name format with the right answer will win special tokens from GPPB TSO. And the question is, Republic Act number 3019 is otherwise known as the A. Government Procurement Reform Act, letter B. Anti-Graft and Corruption Practices Act and other penal laws, or letter C. Anti-Red Tape Act. Again, Republic Act number 3019 is otherwise known as the A. Government Procurement Reform Act, letter B. Anti-Graft and Corruption Practices Act and other penal laws, or letter C. Anti-Red Tape Act. Ayan. Dito sure na ako may tatama na dito. And also while waiting for the majority to answer, reminding everyone to please do not forget to evaluate our research speaker using the Google form link provided by our event secretariat in our Zoom chat box. Okay, we're going to end our knowledge check in 5, 4, 3, 2, and 1. Well, Attorney Isa, we have a 97% answered letter B. At meron pong isa lang po, equivalent to 3% ang sumagot ng letter A. So, sayang, hindi pa na perfect. So, ano po ba, Attorney, ang tamang sagot?
Actually, naintindihan ko yung sumagot ng Government Procurement Reform Act because what we're actually discussing is RA 918 for the Government Procurement Reform Act. Tapos, mention lang yung anti-graft and corrupt practices kasi nga, it also has provisions which are similar or punish the same acts, then punishable ng RA 9184. But RA 3019 refers to Anti-Graft and Corrupt Practices Act. Although, I think you should remove this and other penal laws. Yes, and other penal laws refers to the revised penal code and other acts then. So, yan. Anti-graft and corrupt practices po yan. Anti-red tape act is RA 9485. And of course, yung Government Procurement Reform Act is RA 9481. Okay? So, yan na po.
All right. So,
hello.
yes, this is a special knowledge check nga po, and there will be one winner. We're just going to validate and verify it sa ating Zoom chat box. Again, kapag po nanalo na tayo on our past knowledge check, and also we are already at early birds, we're going to forfeit the special tokens po. So, you know naman guys na we give chance to others. So, we're going to announce the winner on our next knowledge check. We're just going to check po kung sino po ang panalo sa ating special knowledge check. Alright, Attorney, let's continue po our discussion.
Sige. So, we will proceed with the civil liability na. So civil liability refers to the um, next slide. Next slide. Papalayo ba ako sa mic? Okay. Civil liability. Again, just like the criminal liability, the penal liability, this is again without prejudice to administrative sanctions that may be imposed in proper cases. So a conviction under the Act, pag you were found guilty under RA 9184 and this IRR, or found guilty under RA 3019, kasi pare-pareho talaga itong RA 3019 at 9184, no? Shall carry with it a civil liability. Pareho po yung 3019 at 9184 na may civil liability. At this, it may either consist of. Ito, either or. Okay? It's either or. Okay? Meaning isa. Restitution for the damage done or forfeiture in favor of the government of any unwarranted benefit from the act or acts in question or both. No? At the discretion of the courts. Ito po yung sinasabi ko, what is restitution and what is forfeiture? Restitution po presumes that there is damage on the part of the government. Kunyari, na overpriced siya. Nalugi ang gobyerno ng dahil, for example, yung item sana kung mabuti yung pagkaplano, yung especially pagka-determine yung pricing, or kaya yung technology nyo is hindi pala outdated pala at hindi na nagamit later on, nalugi ang gobyerno ng 10 million. Yun 10 million po ang i-restitute ng sino man who were found liable, either public officer or private individual, nakakause ng damage. Yan po ang i-restitute. When you say restitution, it do not require that you gain benefit from it. The fact that there is damage done to the government, na may nawala o nalugi ang gobyerno, magbabayad po kayo. Kahit wala naman kayong nakuha anything. Okay? Wala naman kaming nakuha, ma'am. Bakit kami pinapabayad? Saan namin kukunin ang perang yan? Because sa mga maling nagawa, because of lack of if you fail to exercise the highest standard of ethics, it caused damage to the government. It prejudiced the government. It caused undue disadvantage to the government. At yun po ang i-restitute ninyo. When you say naman forfeiture, there is a presumption that there is a gain or benefit. There's an unwarranted benefit na hindi nyo dapat makukuha beyond your honorarium as back members. Okay? So, any unwarranted benefit na makukuha nyo, it shall be forfeited in favor of the government. Hindi naman pwedeng bakbakin yung tiles, no? Na nag-extend hanggang sa bahay. Pero, yung value, yun yung ipo-forfeit ng gobyerno, ang value ng unwarranted benefit nyo. So, sasabihin nyo, ma'am, nakamura nga kami noon. In fact, very maganda yung kontrata. Sobrang nakamura kami. Ginagamit na ng mga kabataan ngayon. Maraming natutulungan yung project na yan. Ba't kami pababayarin pa? It's because you gain unwarranted benefit. Baka nga, yung unwarranted na benefit na nakukuha nyo could have been more beneficial to the people if hindi nyo tinanggap, di ba? Mas makamura pa. So, yung difference yan, yung restitution, it does not require na meron pa yung benefit for as long as the damage is done, you shall restitute the amount of damage. Yung forfeiture naman, it does not require that there is damage in the government or nalugi. Kahit nga nakaginansya pa sa Bisaya, naka-gain pa yung gobyerno. Kung may gain din kayo, kukunin din po yun as a civil liability on your part. So after ng determination ng penal liabilities nyo, isasama na yun sa decision. Nasa dispositive portion po yun. Kung ano ang penalty nyo, kung may disqualification or may disqualification kayo, either temporary or perpetual, at may babayaran ba kayo, either restitution or forfeiture. Kasama po siya doon. Okay? I hope that is clear when it comes to restitution on forfeiture. Kaya ingat tayo. Hindi ibig sabihin wala tayong natanggap, wala tayong liability. Meron pa rin po pag may damage. Hindi sa ibig sabihin walang damage, wala tayong liability. Meron pa rin po kung meron tayong unwarranted benefit. Okay? Let's proceed to administrative sanction. Okay. Administrative sanctions. Kanina na-mention ko about blacklisting, di ba? So, now we will go again to this administrative sanction by anyway na-discuss na siya earlier. In addition to the penal and civil sanctions na under the jurisdiction of appropriate courts, ito namang administrative sanction, it is the hope who has the authority, no? By delegation of the subject to the authority delegated to the BAC, if any, shall impose on bidders or prospective bidders the penalty of either of suspension and forfeiture. Ito na yung mga time na pwede na si Hope. Sila ang within sa procuring entity lang yung procedure. So the Hope can impose suspension for 1 year or 2 years, depending if it's a first offense or second offense, from participating in public bidding process, and disqualification from further participating in the public bidding undertaken by the procuring entity, and forfeiture of bid security by the performance security or the performance security. Now, after the suspension, of course, if it becomes final executory, walang motion or appeal, or if my motion or appeal na resolve pa rin affirming the decision of the Hope, then the blacklisting order shall follow. No, the procedures I mentioned earlier, it's in GPPB number 40/2017, which was effective on 2018. Yan po yung administrative sanctions natin. Hindi po to yung administrative penalty na perpetual at disqualification. Sa criminal case po yun. Itong administrative sanctions as mentioned in RA 9184 are those sanctions imposed by the procuring entity against bidders who may have committed unlawful acts. Okay, iba yung administrative sanctions naman sa RA 3019. I hope hindi siya nagsagol-lugaw-lugaw sa inyo ng parang nag-ano-ano na, naghalo-halo na. Kasi later naman you'll be given a copy of this. And the truth is, the more you are exposed to actual happy reality. Like for example, nangyari to sa inyo, talaga may nag-file ng protest, or may bina-blacklist kayo, or meron kayong kaso, you're facing criminal or a case on RA 9184, doon naman talaga mas maiintindihan niyo yung provisions under the law. Kasi actual na nangyayari. Okay, may hinaharap na kayo. For now, more on theory na tayo. So let's go to termination of contracts. Next slide. Next slide po. So sa termination of contracts po, sinasali natin ito. Kasi nga, di ba, when it comes to blacklisting during contract implementation, okay lang po kung blacklisting during procurement stage pa siya. Kasi of course, you will not award the contract to anybody who is blacklisted, di ba? Hindi nyo na nga siya, isususpend na siya, hindi nyo na yan i-award. Lalo na pag ma-blacklisted na siya. Now, what happens if it's a blacklisting which happened during contract implementation stage? May contract na. And this is where the termination of contracts provision will come in. Dito na po tayo, ma'am, anong gagawin namin na simulan na? And these are questions that were raised validly to me before, but because of the lack of time, 1 hour lang kasi yung discussion sa ibang wala to, hindi to sinali. So ito nasali sa inyo. So termination of contracts is covered by separate guidelines. It's Annex I of 2016 revised IRR of RA 9184. The object here is to promote fairness in the termination of procurement contracts and prescribe contract conditions and measures to enable the government to protect its interests. Kasi in the end pa rin, kahit when we blacklist individuals or entities, we have to protect our interests. Hindi pwedeng tayo pang ma-thank you, no? Malugi. So the termination of contracts, GPPB Resolution number 07/2019. Next slide. It approves amendments, no, to the Annex I. Ito yung amendments naman yung 2019 issuance ng GPPB. Next slide. Ito yung mga amendments sa mga terminations of contracts. In-amend din dito po yung mga implementing rules ng RA 9184. Yung general conditions of the contract, may mga inalis at may mga dinagdag. yung sa Philippine Bidding Documents, yung PBD nyo, yung sa general conditions of the contract, pati especially sa procurement of goods and clause on liquidated damages of the general conditions of the contract. Ito po siya, next slide po, yung amendment naman sa Annex I. Okay, so whenever you encounter this kind of problem or issues on your project, na ipapa-blacklist nyo na lang yung naglahong parang bula, magician nyo ng mga contractor, no? Na nag-disappear na lang bigla. Ang maging basis nyo is always Annex I of the 2016 revised IRR and GPPB Resolution number 07-2019. So make sure that your PBDs, the PBDs that you are selling or using are still updated, ha? Yung meron na yung mga bagong amendments sa general conditions of the contracts. Okay? Kasi marami na din talagang nabago after 2019. Ako nga, kasi I was away for study leave for more than 2 years. Pagbalik ako, nagulat din ako. Kaya, bakit umikli? So, umikli nga. Hindi na siya ganun kakapal. Pero mas concise din. So, yun. Make sure that you are using the updated na PBD. So, grounds for termination. Ano po yung iba't ibang grounds ng termination which can be applicable in different circumstances that you will encounter. No? Meron tayong, next slide, termination for default. Meron din termination for convenience. Meron for insolvency. Meron termination for unlawful acts, and meron ding termination by contractor or consultant. So by default, wala na tayong choice. I-terminate na talaga yan. Convenience, meaning convenient to you, the procuring entity, hindi convenient ng bidder. Bakit? They choose to enter into contract with us. That is, our offer, it's there for everyone. They choose to take that offer. So there can be no termination for convenience to them, but convenience to us, the procuring entity. Then, termination for insolvency. Ito naman, it's in their favor na rin. Pag nasa ganung level na sila na bankrupt na talaga, insolvent na, there's no use for us na habulin natin. Wala na, bankrupt na nga, habulin. Depende na lang kung ano pang pwedeng mahabol natin. But there is no use expecting that they can still meet their obligations. And termination for unlawful acts. Yun yung mga nakikita natin na mga ginagawa nila, especially in procuring, especially yung mga na-commit nila during procurement, contract acquisition, during procurement stage, na late na lang na-discover. No? And termination by contractor or consultant. Later this one naman, yung termination by contractor or consultant, there is a presumption that on our part, as procuring entity, meron na tayong hindi nagawa na part sa contract. So, ito, isa-isahin natin yan. Termination for default. Isa-isahin natin yan. The procuring entity shall terminate a contract when any of the following conditions attend to its implementation. Kailan tayo magte-terminate by default? Tayo po, tayo ang magpapaterminate niyan. It's our initiative as procuring entity. Si Hope po ang magli-lead niyan. Next slide. In contract of goods. Next slide. Next slide. Sige. So, titigan na lang po muna. Okay. Sabi ko sana titigan nyo muna yung 5 klaseng termination para hindi ako mahirapang balik-balikan. Anyway, nag-move na. So, the procuring entity shall terminate a contract when any, kahit isa lang, hindi kailangan dalawa. When any of the following conditions attend its implementation, meaning during contract implementation na mga acts. In contract of goods outside force majeure, the supplier fails to perform or deliver any or all goods wherein such failure amount at least 10% of the contract price. Kunyari, kailangan niya mag-deliver ng 100 tablets. Wow, 100 tablets. Na-deliver niya lang is 80. Wala namang force majeure. Walang valid reason sa part na yon. No? So, ano mangyayari? Hindi niya na-deliver on the time of the deadline, delivery of goods. 80% lang. So more than 10% yung hindi niya ang failed to deliver. Pwede niyo po yung terminate for default. Okay? Babayaran siya sa amount na na-deliver niya, kung acceptable naman, minus yung liquidated damages, at tapos, iti-terminate na yung contract and let someone take over the contract or whatever other modes of procurement that can be taken, no, to finish that. Kasi, diba? Now, how about if there's a force majeure? May mga pangyayaring nagaganap. Diba? Parang, telecast na news. The supplier, ang 10%, ang determination ng 10% na failure niya, magsa-start po yan, 60 days, 60 calendar days. Calendar days meaning kasama po Saturday, Sunday, ha? But if if the 60th days falls on the Saturday or Sunday holiday, then the next working day, ang ika-60th day. If less than not less than 60 calendar days. Pag 60 calendar days na after receipt of notice from the procuring entity that the force majeure has ceased to exist na, tapos hindi pa rin niya ma-deliver ang full na at least man lang kahit 90% ng contract price, then it can be terminated by default. No? So, dapat at least meron siyang 90%. Kasi pwede naman talaga yon sa liquidated damages, pwede na i-cover sa liquidated damages yung mga delay niya. No? Meron tayong mga deduction sa part niya. Madideduct yung mga delay per day of delay niya sa delivery ng final 10% yung products na remaining products na undelivered, pwede nang i-deduct yun sa yung damages, pwede na i-deduct sa performance security na doon yung unliquidated damages. So, the supplier fails to perform any other obligation under the contract. Wala talagang na-perform. Not only na hindi naka-deliver ng 10%, wala talaga siyang deliver. No? So, wala. Termination by default. How about in contracts for infrastructure project? For contracts for infrastructure project, due to contractor's fault and while the project is ongoing, it has incurred a negative slippage of 15% or more. Okay, ito naman yung mga importante dito. Kaya meron tayong we observe the CPs, di ba? Kasi mag-evaluate yung performance nila. Pag may mga slippage sila, supposedly, magka-catch up plan na sila niyan, di ba? But if they fail to even follow their catch-up plan at umabot na ng 15% yung slippage nila, their fault, not our fault, kasi minsan may slippage kasi yung right-of-way, may problem. And that is a right-of-way, remember people, it's our obligation as a procuring entity. Okay? So kung may yung piece of order din, that's also a valid reason for them not to suspend works then. So if walang fault yung government, walang mga circumstances na nag-absorb. Fault niya talaga. Kung sasabihin niya, fault ng supplier ko, ay fault mo pa rin yun. Fault mo pa rin yun. Eh, bakit yan yung supplier mo? Diba? Hindi niya pwedeng ipasa yun kasi hindi naman tayo nagpabid kayo sa ibang subcontractor at sub-supplier niya. Siya naman yung bidder natin. Siya yung mananagot sa atin. So, yung negative slippage of 15% or more, that is already a ground for termination by default kahit ongoing pa po yung construction. Now, how about after the expiration of contract time? Nag-incur siya ng negative slippage na 10%. Nagdumating na yung date. No, nauna po kayo. Ano po kayo? Nag-about lang ako, nag-change na ng slides. Okay, how about during, yun yung 15% allowed yun if ongoing pa kasi kaya pang ihabol sa catch-up plan. Pero pag tapos na yung supposedly period ng construction, 6 months. After 6 months, may negative slippage kayo 10% due to their own fault, ang fault ng contractor. O, 'di ba? Dapat sana nag-request siya ng extension. Citing valid reasons, pwede nyo namang mag-grant yun. Tapos extend nyo din yung performance security. Diba? But if you fail to, if there's no extension, tapos na-expire yung contract, hindi siya naka-deliver, may 10% negative slippage siya, that is a ground for termination by default. Again, pwede nyo pang ipa-take over yung negotiated procurement by takeover of contracts, yung remaining. No? So, maraming actual naman talaga, maraming ganitong nangyayari. Pero ang ginagawa ng MLGUs, pinapatapos nila. I know, maraming LGUs pinapatapos nila kasi either naaawa sila, nagmamakaawa, or in fairness, kahit naman sinisenda na nila ng show cause order, everyday pumupunta pa rin si contractor, pinipilit habulin yung 10% kahit lagpas na sa contract period. But take note that it is a ground for termination. Okay? So, lalaki lang kasi dapat sana na-remedy yun before pa na-expire yung contract. Kung tutuloy nyo din naman pala yung trabaho nyo, wala na, tatapusin nyo din naman pala, sana nag-extend na lang kayo. Kaya, in your part din, implementing authority, like here sa amin, may mga contracts din kami, tinatry talaga namin i-ask, kaya nyo ba? Pag malapit na, may mga slippage na ina-ask talaga namin sila. So, if you want to, tapos dapat mag-extend sila, pero nakikita din namin na may plan sila. Kasi mahirap kasi pag magko-compute kasi there is a law and any deviation from the law, it might cost us our jobs, no? And it may cost them also profits. So in contracts for infra projects, also, the contractor commits any or all of the following. Ito pwedeng niyang gawin na pwede terminate by default. Inabandon niya yung contract work. Next slide po. Inabandon niya or nag-refuse or fail to comply siya with the valid instruction of the PE. Andun pa rin yung mga nahukay, hindi inaalis. Paano namin magagamit yung daan kung yung mga nahukay na mga asfalto, hindi nyo inalis? No? Tapos kasama yun sa contract nyo. No? So that is considered abandonment pag hindi nila nilinis yung area. Does not have a listed minimum essential equipment in the project site. Pagpunta nyo doon, dapat sana na kayo, di ba? Grader na sana ang nandoon. Wala namang grader doon. Andun lang isang tao na naghihintay. Saan po equipment ko? May minsan nakaka-join ako dati ng mga project monitoring. Minsan pagdating namin doon, isang tauhang gutom na lang ang natira. Naghihintay kung kailan siya babalikan ng project engineer kasi kailangan yung wala na siyang pagpamasahe pa uwi. So yun yung mga problem ina-abandon na ng contractor. Kasi nalugi na. Baka nga naman, naubos na yung said na yung baon. So, again, also, when do not execute the works in accordance with the contracts or neglect to carry out its contractual obligation, then neglects or refuse to remove materials or perform new work that has been rejected as defective or unsuitable. Yung mga daang butas-butas or kaya weak, parang sabi nyo, bakit ganito yung na-discover na yung mga bars na ginagamit, hindi yung nasa approved plan, rebars, tapos hindi pinapalitan, tinatakpan pa. So, yun yung mga, kasi kayo, di ba, meron kang project monitoring team, may nag-inspection doon sa site. Tinitingnan kung tama ba, in accordance with the plan ba. So, hindi pwedeng, unlike in a real life, sa atin, sa mga bahay-bahay natin, na minsan, niloloko lang tayo ng mga forma natin. Doon kasi we are expected to be professional. So, hindi pwede yung mga palusot nila, ha? Ay, hindi ganyan talaga ito. So, pwede nyo yung you call out the attention of the project engineer. Tapos, pag hindi nila kayang i-change yun, kasi defective or unsuitable, then it's a ground for termination of default. Why? Because it can cause more problems later on. Sublets any part of the work without approval. Pinapagawa nila yung ibang parts of work without approval of the PE. Like for example, yung mga welding aspect or yung may mga pwede silang i-sublet, dapat ipina-subcontract nila, dapat maalam nyo. Okay? But it doesn't mean alam nyo, nagka-consent kayo na iba-iba na yung liability nila. Join pa rin po yan. So, kahit may consent sa inyo na mag-subcontract sila, any delay would still be the liability of the contractor. No? So how about in contracts for consulting services? Next slide. Outside force majeure, the consultant fails to deliver or performs the outputs and deliverables within the period specified in the contract or within any granted extension. May nangyayaring ganito, no? Especially nung mga CDP nyo, mga CLUP nyo, meron kayong mga consultant yung iba, nagpatulong kayo. After the contracts, wala, hindi pa rin makadeliver. that is a ground for termination, no? And that person should be blacklisted. He cannot claim that he's an expert when in fact he's not able to deliver, no, his output. As a resultant of force majeure, the consultant is unable to deliver or perform a material portion of the outputs on the deliverable. Pag ito talaga, just like goods, it depends kung may force majeure o wala. Pag walang force majeure, walang mga pangyayaring, for example, yung may mga, marami kasi yung force majeure na mga force majeure, mga bagyo, lindol, mga pangyayari, it's either man-made or nature. Man-made or natural calamities. Yun yung mga example natin na pwedeng makadelay sa delivery. So it's either goods or consulting service or delivery of goods. Iba-iba yung allowances natin. Walang allowance pag outside force majeure. Pag delay, delay. Pero pag may force majeure, ang requirement lang yan is 60 calendar days after notice from the procuring entity that the force majeure has deemed to exist, dapat mag-deliver na sa 60 days is quite long. It's 2 months. So, hindi na sa pwede magsabi, ma'am, kasi binagyo lahat, nabasa lahat ng research ko. You have 2 months to gather that again. If you are actually the one doing your research, you can find your materials again. If, yun nga. Kasi daming mga sub, di ba? Kinokopya lang sa iba. Parang thesis lang, kinokopya ng iba sa iba, binibili. So the consultant fails to perform any other obligation under the contract. Kunyari, sa consultant nyo, nire-require nyo mag-perform siya every week, he should make a report. Or dapat may exit conference siya na ma-organize. Diba? Tapos hindi niya nagawa. Or may survey siyang pinaganito, may plans siya na i-submit every month. Wala siyang na-submit. You don't need to finish the contract duration and see if he can deliver or not. Yun pa lang pwede nyo nang i-terminate yan. If he's not already performing the other obligations under the contract before the contract ends, how much more pa kaya when the contract ends? Wala talagang ma-deliver yan. Wala ang update sa inyo ni ho. Diba? So the procuring entity naman for termination for convenience. So yun po yung termination for default at the option of the procuring entity. Yan po, when it comes to infrastructure, projects, consulting services, and goods. Yan po yung mga earlier na mention ko some of them in the blacklisting during contract implementation stage. Yan. Kasi pwede grounds din po yan for blacklisting. Not only for termination of contracts, but for blacklisting. Now, let's go for termination for convenience. Oh, we only have 30 minutes left. I think I will need to extend talaga for the Q&A, no? So, for convenience naman, it's a procuring entity. This time, it's a procuring entity, again, who has the option to exercise this at any time for your convenience. For example, i-determine lang po inang hope the existence of conditions that would make it the project implementation either economically, financially, or technically impracticable and or unnecessary. Kasi, for example, there's a change in technology. You don't need this technology anymore. So why continue with the project? Even if may notice of award na kayo, you can actually terminate that for your convenience. Because otherwise, pag ma-deliver nila yan, tapos mabayaran nyo, and then later wala na, nakatiwangwang na lang, thank you din. Okay? So, or financially, na-withdraw yung source of funds nyo. Because not all the time, the source of funds comes from you. Minsan galing sa DILG. Tapos, because of the delay of some things, maybe na-delay sa level ng Development Council or ng mga ibang requirements yung hindi nyo na-submit, na-withdraw yung funds. So, of course, it's already financially impracticable for you kasi wala naman kayong ibabayad doon kasi hindi yun yung inaasahan yung source of funding ng projects nyo. Pwede nyo po yung i-terminate for your convenience kahit may award na kayo na contract. Then, economically, there are inflations going on, especially during the time of pandemic. Maraming na-terminate for convenience na. Yung mga hindi pa nasimulan, kahit may award na na-terminate. Why? Because at that time, it was crunch time. We were saving as much money as we can. to support kaagad sa mga lost livelihoods, at the same time procurement na needed during pandemic. So yun, yung termination for inconvenience. Take note that termination for convenience can be done at any time. Okay? So wag niyo, hindi pwedeng sabihin, ma'am, nag-start na at any time. But of course, make sure din na hindi din, you make balancing of interest. No? You make balancing of interest na hindi rin kayo, remember, you're a corporate entity. You're a corporate entity, you can also be sued if may damage na din kayo. You have to pay also for damages. No? Baka, pero minsan kasi mas maliit pa yung damages kaysa total loss niyo. So, preferably, you terminate only those that have not been started yet. Yung may notice of award, yun hindi pa lang na-start. Preferably. Then, termination for insolvency. We'll go for termination for insolvency. Ito yung may judgment na talaga from a competent court na bankrupt na or na insolvent na si supplier, hindi na niya matapos yung contract. Next slide po. So yung bankruptcy or insolvency must be determined by a court of competent jurisdiction. Hindi pwedeng sabi niya lang, wala na akong pera, hindi pa po bankrupt yan. Bakit? May assets pa po siya. Okay? Once mabankrupt na yan, insolvent na yan, there will be an insolvency proceedings na wherein all his assets, pati yung mga non-liquid na assets, shall be distributed to his debtors, to his creditors, no? So, yan po yung mangyayari pag may insolvency proceeding. So, pwede nyo nang i-terminate yun for insolvency ang contract. Huwag na kayong makisali later na line up pa kayo sa preference of credits. No? Termination will be without compensation provided that such termination will not prejudice or affect any right of action or remedy which has accrued or will accrue thereafter. Yan po yun. So, need po ng court order. May finality na. Terminate, paano po, how do you know it's final? When there is already entry of judgment. And you know, the next thing that would follow in insolvency court order is insolvency proceedings. Huwag sana kayo makipila na doon. Dapat na-terminate nyo na. So, termination for unlawful acts. This was the one I mentioned, where the unlawful act was committed during contract acquisition din. Huli nyo nang na-discover. So, pwede ito kasama, ha? Ma'am, na-award na namin ang contract, later na-discover namin, may bribery pala. Binayaran pala niya yung dating na-suspend na namin na yun, na may temporary suspension na back secretariat head namin, o isang staff namin. Ganun. So, that's an unlawful act. It is still a ground for termination. So, the procuring entity may terminate the contract in case it is determined prima facie that the supplier, contractor, or consultant has engaged before or during the implementation of the contract, and before, during procurement station, or during the implementation of the contract, meaning after notice of award, in unlawful deeds and behaviors relative to contract acquisition and implementation. So, termination for unlawful acts. That's it. Next, of course, unlawful acts would be, of course, you go back to the corrupt, fraudulent, collusive, coercive acts. Next slide. Next slide. And next slide again, kasi binasa ko na lang corrupt, fraudulent, collusive. So, termination by contractor or consultant. Kailan naman pwedeng sa contractor or consultant na ang terminate, hindi kayo as procuring entity. For infra projects, the contractor may terminate his contract with the procuring entity if the works are completely stopped for a continuous period or for at least 60 calendar days through no fault of his own, hindi niya kasalanan, or for the following reasons. Failure of the procuring entity to deliver supplies, materials, right of way, or other items under the terms of the contract. Minsan sa terms of contracts natin, nilalagay natin kami ang magpo-provide nito. Diba? Kami ang magpo-provide nito in order to make it cheaper, maybe, or make it convenient then. So, pag hindi nyo na-deliver yan, or kaya yung right of way, hindi nyo na-prepare, hindi kasalanan niya ng contractor. In fact, he can terminate that, no? Because 60 calendar days na. Siyempre, nagpa-price escalate yung mga prices, diba? May price escalation sila. If matatagalan yung implementation niyan, malulugi siya. Kung hihintayin niya kayo, kailan kayo maging ready. Kaya pwede niyang i-terminate yan. Then, work also is disrupted by adverse peace and order. Ito basically, isa-suspend niyo lang yung works. The suspension of works to ang solusyon yan. But if hindi talaga after continuous period na wala pa rin talaga, yung peace and order is really a problem as certified by the AFP Provincial Commander or approved by the Secretary of National Defense, then he can already terminate. Why? Because prices change. He cannot wait forever. Kasi mababaon siya doon sa price under the contracts. No? Matatali yung kapuhunan niya. Pero hindi din naman niya makukuha yung bayad kasi nga he cannot continue. So he better use his resources on other projects, not yours. So yun po yung contract termination by consultant in infra projects. How about in consulting services? Before tayo mag-knowledge check, the consultant may terminate its agreement with the procuring entity if the latter is in material breach of its contractual obligation and has not remedied the same within 60 calendar days from notice of consultant specifying such breach. For example, yung consultant kasama sa terms niya, i-provide siya ng staff at computers. Tapos din niya na ibigay. Wala siyang staff. So, paano yan? Paano siya gagawa? Paano siya? Wala nga sasakyan for him to do the surveys in the area. Hindi niya alam saan ba yan yung pinapupuntahan niya sa survey ko. So, if course, he is a matter of right, he can ask for termination of the contract. So, we will have knowledge check before we go to the procedures. Huh? And then, I think that is the last discussion sa yung procedures.
All right, we are now on our second knowledge check for this topic. And again, may I request everyone in our Zoom participants to choose your answer in our Zoom polling feature. And the question is, the procuring entity cannot terminate the contract at any time for its convenience. Is it true or false? Again, the procuring entity cannot terminate the contract at any time for its convenience. Is it true or false? Natatandaan ko pa yung statement na ito habang dinediscuss ni Attorney Aiza. So hopefully guys, alam nyo ang sagot po dito sa ating second knowledge check. Alright, we're going to close our Zoom polling feature in 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. All right, there we have it po. Attorney, we have 67% answered false while 33% answered true. Attorney, ano po ang tamang sagot para po sa ating knowledge check?
Of course. The answer is false. Ay, marami pa rin nabibiktima sa negative line of questioning, yung negative natin, yung posing ng question. But the answer is false. Why? Because the government, the procuring entity, can terminate a contract at any time for its convenience for as long as it can be determined na may existence ng conditions which should make the project implementation economically, financially, or technically impractical or unnecessary. So meaning at any time, basta ma-determine lang yung existence. No? Na impractical na siya, hindi na siya necessary. Okay.
All right.
So that's it. The 60% were able to catch the flow of the question.
All right. Thank you po, Attorney. Let's continue po our discussion.
Okay, we will proceed with the procedures for termination of contract. So how do we do it now that we know the different kinds of termination and also the different instances where we can terminate by convenience, unlawful acts, insolvency, and even by contractor or consultant. They also have the option to ask for termination of contract if kayo naman ang nagkulang. Charot. And so we will proceed with the procedures. So procedures, this is the summary of the procedure. Ito yung flow chart. It starts with, of course, the verification. The verification ng grounds. Then the notice to terminate. Kasi you have to have first verified report. May report dapat showing grounds for termination. So depende saan papasok yung termination nyo. By default ba? Insolvency ba? Unlawful act pa or convenience pa. After that, you send notice to terminate, no? Then, of course, after the notice to terminate, they will show cause order. Yung contractor or supplier or consultant will show cause why it should not be terminated, especially if dun sa mga unlawful acts tayo or by default, baka nga naman may justifiable reason sila, no? Before the rescission of notice of termination and the decision. So we will go one by one now. So verification, there must be a verified report. Next slide. The implementing unit shall within 7 calendar days from receipt of written report of acts or causes which may constitute grounds for termination shall verify the existence of such grounds and shall execute a verified report with all relevant evidence attached. So that's why it is not an excuse really when you say, Ma'am, hindi natapos. Before that, wala bang nag-monitor sa inyo sa project? So at least makikita nyo na if there's already negative slippage, you have terminated the contract earlier. Sana yung remaining amount ng contract, may taker pa yan. Hindi lugi yung mag-take over. Diba? So, yun talaga importante. Kailangan kung may mga reports na on certain acts or causes which may constitute grounds for termination, puntahan na yan, i-verify na yung existence and make a report to a verified report with all relevant evidence attached. So, that is the reason sa inyo sa MLGUs, the barangays where the project is located, your project engineers or your supply officers, the implementing unit, kung saan sana i-deliver yung yung inspection officer, they could have already make a report on that. The next slide, we will proceed. After you na-verify, meron na kayong verified report, no? You will go proceed with the notice to terminate. The hope shall terminate contract only by written notice. Hindi pwedeng verbal. There should be a written notice to the contractor or supplier stating therein the following. What are the grounds for termination na you relied upon? The statement of the acts that constitute the grounds for which the contract is being terminated. Ano ang grounds at ano ang acts na nagawa? Then, extent of termination. Ano ang ite-terminate? Ilang percentage ng contract ang ite-terminate nyo? No? Kasi depende. Then, wag yung i-terminate yung nabayaran nyo na ipatapos yung gawin, yung nabayaran nyo na. Okay? Ite-terminate nyo na lang yung pwede pang masalo ng iba. Okay? Sa takeover of contracts. And instruction to the supplier, contractor, or consultant to show cause. Why the contract should be terminated. Ito naman, if causes lang, especially if the allegation is hindi yung convenience, hindi yung insolvency, kundi yung termination by default at termination because of unlawful act, ito, pwede ding may instruction kayo sa supplier or contractor, consultant to show cause why the contract should be terminated. No? Pag insolvency naman, i-attach na lang yung court order. No? I-attach na, nasa kanya na din yun if i-argue pa niya yung final executory na paano niya i-argue yun. No? So, notice to terminate yan po yung laman ng written notice to terminate nyo. Bigyan nyo ng grounds, ano yung acts, extent of termination, ilang percentage ng contract, at instruction if they can show cause. The next slide, show cause naman. Ito naman yung a verified position. Again, like any show cause, it must be a verified position paper. Diba? Remember, in blacklisting during contract implementation stage, unlike yung sa isang blacklisting during procurement stage na sobrang mahaba yung procedure, ito namang sa contract implementation stage, tatlo lang, di ba? Show cause order, notice, show cause order, at decision. Same din yan sa termination of contract. Merong written notice, merong show cause. It must be verified position paper, no? Submitted to the hope within 7 calendar days from the notice of termination. So, failure by the supplier or contractor consultant to submit the verified position paper shall cause the hope to issue an order of termination. So, issue na niya yung order of termination niya. Hindi po to same sa blacklisting. While it can go together, lalo na kung ang grounds ng termination is the same grounds as blacklisting, pero may mga grounds din ng termination na not a ground for blacklisting. But the same ground can be used for blacklisting and termination when they go together. Dalawang notice kayo. May blacklisting order pa kayo, may notice termination pa kayo. Diba? Order of termination pa kayo. So, decision. When it comes to termination, the decision must be within a non-extendable period. Decision pa po tayo. Decision na pa tayo. Hindi na po ako ng withdrawal of notice to terminate. No? Kasi depende naman yun. May verified report. Okay, next slide po. Na-skip ko pala to. So, the PE may withdraw the notice to terminate at any time. So, kahit meron kayong notice to terminate, pwede nyo namang i-withdraw yan at any time before pa po sumagot yung contractor or consultant. Okay? It shall be based on your determination of the items of works. No? Baka nga naman, na-deliver or natapos din nila before within those period na na-report. So, pero kung hindi, mag-submit siya ng verified position paper niya within 7 calendar days, tutuloy niyo yan. So, notice to terminate, bumabalik tayo, umaatras tayo, umaatras tayo, nawawala na. So, let's go to decision. Okay, after ng show cause order, you will, the hope shall decide within 10 calendar days na upon receipt of the verified position paper. To submit show cause order, yung verified position paper nila, then automatic na yung order of termination. Hindi na kailangan ang decision. So termination shall be based on the grounds stated in the notice to terminate, and hope may create a contract termination review committee to assist him in the discharge of his functions. So pwede din siyang gumawa ng contract termination committee, especially if the contract is very complex. If the project is very complex, he can create a committee for that para naman matulungan siya to determine especially the extent of termination. So all findings or decisions of the CTRC are subject to the approval of the hope. Of course, the hope is still the final arbiter. No? So, yan, 10 calendar days niyan, decisionan yung verified position paper with or without the help of a contract termination review committee which he has the option to organize. Next slide po. So, yan po yung decision. Okay, the final approval of the decision, whether or not there is a review committee, is with the hope. And after the decision, of course, order of termination shall follow. So, termination order na. The decision, order of termination. Order of termination, automatic yan pag walang sagot. Pero pag may sagot, dapat may decision muna before order of termination. Now, what will happen to the contract that's left behind? Yung hindi natapos na portion ng contract. Next slide, what will happen to the contract na hindi natapos? Yung portion ng contract na hindi natapos. That's when alternative modes of procurement will come in. Meron tayong negotiated procurement, takeover of contracts. If a procuring entity terminates a contract due to default, insolvency, or for a cause, for example, yung convenience, walang magti-take over of contract ha, kung convenience, kayo nga yung nagsasabi na impracticable or unnecessary na siya, tapos maghahanap kayo na magti-take over ng contract. No po. Ha? Take over of contracts, it will only be applicable pag yung termination is caused by default, by insolvency, or for a cause. So it may enter into a negotiated procurement. Negotiated procurement na po yan. And I think it was discussed to you yesterday extensively already. Yun po, napapasok na po yung nalalaman nyo sa takeover of contracts. So, Section 53 po yan siya, no? So, the contract may be negotiated starting with the second. Sino po yung second lowest calculated or highest rated bidder nyo last time na pinabid nyo yan, no? At the bidder's original price, okay? At the bidder's original price. If negotiation fails, the negotiation shall be done with the third lowest calculated highest rated bidder na naman. Next slide. At his original price pa rin. If the negotiation fails again, a short list of at least, pag nag-fail kayo sa second lowest at the original price, huwag mo na kayong mag-adjust ng price nyo. Kasi sabihin, ma'am, nag-inflation na hindi na applicable yung price namin dati. Huwag mo na, punta mo na kayo sa third lowest. Kasi nga, di ba, third lowest siya? Meaning, mas higher yung price niya. So, meaning din, baka kaya niyang i-cover yung whatever price escalation that happened in between those times na nagsubmit siya ng bid niya at yung times na in-approach niya na siya for negotiated procurement. Pag nag-fail pa rin sa third lowest calculated and responsive bidder, lowest rated bidder, hindi pa naman responsive kasi ano niyo pa yan. Doon na kayo mag-come up ng shortlist of 3 eligible contractors who shall be invited to submit their bids and negotiation. Shall be made starting with the lowest one. Okay? Yung sinasabi po dito, hindi po ibig sabihin na negotiated na kayo. I-dispense nyo na po yung eligibility. Make sure that they are still eligible. They still have their valid field jobs, they still have their valid mayor's permit, their tax clearance, no? They're still eligible, kumbaga. Hindi ibig sabihin negotiated, ipo-forgo na natin yung requirements. So, authority to negotiate, sino ang magbibigay sa kanila ng lowest? So, it could be yung lowest na is even higher, with the amount higher than the third lowest pa. Diba? Kasi hindi yan maiwasan eh. Nag-escalate na yung price. Huwag kayong mag-stick sa price. Basta pasok lang din sa ABC nyo. Pag hindi talaga, you have to find a way din sa budget nyo. Kung budget na lang. No? Planetary budget. So, procedures, authority to negotiate contract for projects under these exceptional cases shall be subject to prior approval of the head of a procuring entity. No, depende din. Like sa amin, may limit yung negotiation sa hope namin. Sa inyo naman, wala. Sa MLGUs. So, yung authority to negotiate contracts, same din yan sa the fact that is sa authority to enter into contracts, meron na yung amount at project proponent niyan, di ba? So, of course, it includes the authority to negotiate the contracts unless the negotiation goes beyond the amount authorized in the approved budget. So, yun. Hingi kayo uli sa sanggunian ng authority, additional authority dyan. So, it's a different thing when it comes to LGUs kasi you are bound by different rules din, especially sa powers ng hope. Meron kayong authority. Yung authority to enter into contract, nasa budget yan. Or separate authority to enter into contract. Pero, pag ang amount, nag-go beyond na, need nyo na ng additional, kailangan nyo na yung dumaan ulit. Kasi di ba power of the purse naman talaga yung sanggunian. Hindi pwedeng magne-negotiate kayo ng amount na hindi naman ino-authorize ng sanggunian. Okay? Kasi maging gera talaga yan between the legislative and the executive. Then procuring entities, options, and termination of convenience. Last slice na po tayo. Applies only. Yung termination for convenience po applies only to contracts for goods, no? The goods shall be accepted if performed or are ready for delivery within 30 calendar days after receipt of supplier's notice. Goods not yet performed or ready for delivery, yung hindi pa na-start, hindi pa na ready for delivery, the procuring entity may elect to have any portion delivered or performed and paid at the contract term or price. Kanyari, 100 sana, sabi nila, impracticable na, pwede to 50 na lang. Pwede din yun. Na-terminate nyo na yung 50% of the contract. Or to cancel the remaining and pay the supplier. Cancel nyo na yung remaining na hindi pa na deliver, hindi na kami, okay na kami dito, na 80 shirts lang, okay na kami, hindi nyo na kumpletohin yung 150 shirts. Okay na din yun. No? It only applies for goods. Why? Because sa goods kasi, re-return naman yan, hindi naman yan specifically manufactured lang para sa inyo, di ba? Or hindi naman, lalo na yung hindi pa ready to deliver, pwede pa namang makancel yun. But when it comes to infra, my God, syempre, naghukay na yan. Tapos terminate nyo for convenience. Anong gagawin nyo sa hinuhukay nila? Paano na ba nabayaran yung naghuhukay? Diba? Alam nga naman, ibabalik nila yung lupa. Kahit ibalik nila yung lupa, trabaho din yun. Babayaran din yun ng ilang days, 'di ba? Sa nahukay na. Luta kaya nakatayo na doon yung pillars, or nandiyon na yung mga foundation. Hindi na yan i-terminate. Yung goods lang yan talaga. At also, depending din sa goods. Kung may na-delivered na portion, or yung undelivered pa, or ready or not yet ready din for delivery. No? So notice, yung procedures naman for termination of contracts, for contractor or supplier, Kasi yung flowchart na pinakita ko kanina, naalala niyo yun? Nag-a-apply lang yun sa termination by default, unlawful act, or yung sa insolvency. Pero yung sa termination by convenience, ito nga yung procedure niya, iba, di ba? At especially yung termination na yung contractor mismo or consultant nyo ang nag-demand. Wala na siyang diwala sa inyo. So notice, written notice must be served. Siya naman ang magsiserve ng notice sa inyo at least 30 calendar days before its intended termination. Contract is deemed terminated if it is not resumed in 30 calendar days. Nag-inform siya sa inyo within 30 calendar days. Sabi niya, ngayon is August 19. Sabi niya, in September 19, I intend for the contract of ANA for this project to be terminated because hindi pa rin kami makapasok sa project site. Kung within 30 calendar days, hindi talaga niya ma-resume yan because of the same problem nga na na-mention niya, then it's deemed terminated na. But within 30 calendar days, nagawa niya ng paraan, then wala na siyang reason. No? Kasi before pa dumating yung intended date of termination niya, yung reason niya is nawala na, cease to exist. Kumbaga, bakit mo ito-terminate on the ground na hindi namin na-prepare yung right of way? Andyan na nga, na-prepare na namin ang right of way before your intended termination. So, nawala yung ground in his favor. So, hindi na yun ma-terminate. Okay? So, and that's it for our discussion on termination of contracts. Again, summary, termination of contracts by default, by convenience, by insolvency, by unlawful acts, either during contract acquisition or during contract implementation, and by contractor or consultant. So that's it for our discussion on penal, civil, administrative provisions plus contract termination. Now let's check.
All right, before we officially end our learning session for today, we still have one remaining knowledge check. And again, kindly choose your answer in our Zoom polling feature. And the question is, in this procedure for termination of contracts, a verified position paper shall be submitted by the supplier, contractor, consultant to the HOPE within 7 calendar days from receipt of the notice of termination. Letter A, verification. Letter B, notice to terminate. Letter C, show cause. Letter D, rescission of the notice of termination. Or letter E, decision. Again, the question is, in this procedure, for termination of contracts, a verified position paper shall be submitted by the supplier, contractor, or consultant to the HOPE within 7 calendar days from receipt of notice of termination. Is it A, verification? Letter B, notice to terminate? Letter C, show cause? Letter D, rescission of the notice of termination? Or letter E, decision? All right. Again, kindly choose for your answer in our Zoom polling feature. And now, I'm going to announce the winner of our special knowledge check kanina. So upon verification po of our technical team, our knowledge check winner is from MLGU Mauban, Quezon, Maria Lea P. Malubay. All right, congratulations, ma'am. Our technical team will send a direct message po on how you may claim your special tokens from GPPB. All right, again, on our last knowledge check, we're going to close it in 5, 4, 3, 2, and 1. There we have it. I believe we have 45% answer letter C, show cause. We have 18% for both verification and letter D, rescission of the notice of termination, and 9% po on both notice to terminate and decision. Attorney, ano po ang sagot sa ating final knowledge check?
Anyway, kahit hindi man majority, plurality of votes naman. Yes, it's during show cause. Doon po magsasubmit yung supplier contractor ng verified position niya. Kasi nga, di ba, supposedly, yung verification, yun pa lang yung time na matanggap nila yung report na may mga unlawful, may acts or causes for na nakapag-delay ng could be a ground for termination of the contract. At yun yung po i-verify nila. Hindi pa po sumasagot dito yung supplier or contractor. Ang implementing unit pa lang po, yung procurement entity pa lang po, ang nagde-determine yan kung merong bang grounds. Yung notice to terminate, supposedly eliminate na po yan. Kasi nga dito sa question nyo pa lang, within 7 calendar days from receipt of the notice termination. So, di ba? So, meaning, it's after notice of termination. So, the next thing is, of course, show cause order. After the notice to terminate, yung show cause order. Ito na mga rescission of the notice of termination. Minsan kasi, even before, I think there was a fault on our part at that time, no? Kasi medyo na-skip ko, tapos naggulo din yung presentation ng slides. Yung minsan kasi, even after a notice of termination has already been sent to the supplier or contractor by the procuring entity, but before the submission of the verified position paper, nire-resend nila, ni-withdraw nila. Bakit? They found out later and it was completed. Before pa yung required na 7-day calendar day for them to submit, na complete na yung performance or delivery ng goods, kung goods, di ba? So, nire-resend na lang yung notice of termination. It happens. Hindi naman lahat ng notice to terminate, it proceeds diretso sa show cause. Pero pag walang enough reason si Hope na i-resend, bawiin yung notice of termination, then the supplier contractor has to submit its verified position paper within 7 calendar days. If hindi niya gustong mangyari na diretso sa order of termination, na at least man lang may decision at chance siyang sumagot. So yung decision, it follows after a show cause order. And decision preludes the order of termination. Okay? Or kasama na doon yung order of termination sa decision. So that's it. The answer is letter C, show cause order. A lot of people got the right answer anyway, so it's more than satisfactory.
All right, thank you so much, Attorney Isa. I believe that ends our discussion proper for today's learning session. Again, thank you po, Attorney Isa, for a very exceptional discussion of penal, administrative, and civil provisions. All right, to proceed with the open forum, please be reminded that questions gathered in the Zoom box, Zoom chat box, and Facebook Live and YouTube live stream comment sections are filtered. Now, once again, let's have our research speaker, Attorney Isa.
Yes.
Yes,
what are questions?
For our first question, is there any chance po to reject the appointment of being a back member or TWG? Is there any administrative sanction?
It's the Hope's discretion po talaga sino ang i-appoint niya. For as long as there is no prohibition on your part. For example, if you are the accountant, you're not supposed to be appointed, no? Or you're a sanggunian member, you're supposed to be appointed as a back member. So, that is a valid ground. But if you don't have valid ground, and then, pwede nyo pakiusapan yung mga mayors nyo kung papakinggan kayo. Pero if mag-insist na mayors nyo, that would be insubordination in your part if hindi mo tatanggapin yung designation. Yes.
All right, thank you po, ma'am. For our second question, we have here, is it allowed to terminate contract with any suppliers with unethical behavior?
Yung unethical behavior, kung yung unethical behavior niya is pasok naman sa unlawful acts, that is also a ground for termination. Termination for unlawful acts. Diba? May mga enumerations tayo earlier. Pero kung unethical behavior niya lang, nang luluwa siya, nang dudura siya kung saan-saan, or nang curse, yung parang masama lang yung bigkas, hindi naman kasi ground for termination of contract and unlawful acts or contract implementation. Okay?
All right. Thank you po, Attorney. We have our next question here. What if ang collusion po ay between Hope and bidder? What is remedy of back?
Oh, the back doesn't necessarily have to with the remedy. No? Kasi truth is, kahit ano naman yung resolutions nyo, kung hindi yan kakonsider, di ba, kayo yung nag-conduct ng procurement. Hindi yan ika-consider ni Hope kasi nga may collusion sa every bidder. Wala naman kayong magawa doon. But anybody could file a complaint against them. Even you could file a complaint against them, pero gustuhin nyo ba? Ako, matanong ako, familiar ako sa nature ng MLGUs eh. You are still one family. Very rare ako naka-encounter ng instance na ang members ng bank ang nagre-reklamo mismo sa Hope. Okay? But it could be other bidders, and when there is a subpoena already on your back documentations, your mga records of proceedings nyo, doon nyo yun ilalabas. Hindi pwede kayong magtanggi. Pag tatanggi kayo sa subpoena, other than ma-indirect contempt pa kayo, matudahan din kasama kayo sa collusion. But for as long as the collusion does not include you, walang any evidence na kasama kayo, libre po kayo. Wala po kayo. Wala po kayong liability.
Alright, thank you po,
Kasi
attorney,
minsan
for...
ibang bank, kaya alam ko minsan inisip ng ibang bank na they have to take actions, otherwise baka madamay sila sa kaso. You don't need.
Alright, thank you po.
Scenario.
Alright, scenario. A contractor supplier presented a falsified document, says that a contract previously entered, according to the omnibus form statement, all documents he is presenting are correct. However, there is also stipulation for the procuring entity that they are free to check and confirm the legitimacy of their documents. What is the liability on the part of the procuring entity if the documents were found later are falsified?
Oo. Dapat talaga sa post-qualification yan. Kasi mag-question yung process ng post-qualification. Did you not check the legitimacy of the document? Kaya importante po talaga, yung TWG natin are very masisipag din at techy, marunong maghanap. Kasi any findings na later on, pag may magreklamo na falsified yung documents nila, and we failed to exercise the highest standard of ethics in doing our job, baka madamay tayo sa okay? So, at least, if you siyang magtago, that is a good defense on your part. Pero later, sasabihin sa inyo, hindi nyo na-check yan sa post-qualification? Andyan lang naman yan sa website ng PCAB. Andyan lang yan sa online blacklisting portal. Andyan lang naman yan sa website ng BIR. Tapos hindi nyo na-check, that is on your part also. Kung hindi man sa RA 918 for another laws against public officers, meron tayong mga other applicable laws, di ba? Mas sa RA 3019 yan. That's Anti-Graft and Corrupt Practices Act. Kasi malfeasance on your part. You failed to do what you need to do. What you ought to do.
All right. I believe that was our last question. So if you have more questions, you may still ask them out by visiting Slido.com. All you have to do is to just type in the event code #governmentprocurementph, to which the GPPBTSO will answer through an issuance or through FAQs. At this point, we would like to thank again our research speaker, Attorney Isa Fiel Nogra, for all the time accepting our invitation and for extensively and enthusiastically attending to the concerns and questions raised by our participants on both of our learning sessions. And to our participants for the last time, from Zoom to Facebook and YouTube live streaming, who actively participated all throughout the course of our program, we thank you all very much. And again, to the winners, or to our winners, congratulations po, and please do check your emails or chat box and kindly provide us the details needed for us to ship your respective emails. Now, may we request everyone to please switch on their cameras to commemorate this learning session with our resource speaker, Attorney Isa Fiel Nogra. All right, may I see your beautiful faces for the last time? Diba? Mamimiss ko kayo, guys. All right, let's smile. We're going to have a 3 shots again. And first shot po in 3, 2, and 1. Second shot po in 3, 2, and 1. And for our last shot in 3, 2, and 1.
All right. Again, thank you so much po, Attorney Isa, and to our participants. So before we proceed to the final reminders, allow me to provide a recap or bird's eye view of our today's learning session. So as our session ends, we have an in-depth discussion regarding protest mechanism and remedies, where we learned the grounds and remedies of offenses committed in relation to the conduct and or participation to procurement activities, and understand the procedures and considerations on how to resolve a request for reconsideration or protest. We also have understand the procedures on imposing administrative sanctions in the form of blacklisting to bidders who committed any of violations during the competitive bidding or contract implementation stage, and gain substantial knowledge on the responsibilities of the back secretariat, observers, bidders, and the end users or implementing units relative to the issuance and posting of the blacklisting order. On the last learning session, we are reminded about the highest form of ethics through the discussion of penal, civil, and administrative provisions, highlighting its clause, offenses, penalties, and sanctions. We also discussed the guidelines on termination of contracts, also its grounds and procedure. Our today's session is led by our GPPB recognized trainer, Attorney Isa Fiel Nogra. So thank you so much, Attorney, for accommodating us. Again, for final reminders, as part of our requirement for the provision of the issuance of certificates, please do not forget to evaluate our today's research speaker by clicking through the Google form link shared by our events secretariat in our Zoom chat box. This is two-part, the general evaluation and also the resource speaker evaluation. Note that your response are still editable under the edit button. So for evaluation of resource speaker, you may evaluate Attorney Isa now. Rest assured, all information shall be utilized for documentation, planning, reporting, and processing, and shall not be used by any parties other than the authorized staff of GPPBTSO. Ayan. Again, certificates of completion shall be only given to those with complete attendance and evaluation requirements. So, all right. So we would like to thank all LGUs who attended this training and participated in our third batch of MLGU online training on RA 9184. I know that you have a great learning experience in the 5-day session in the procurement laws, rules, and regulations, though I think 5 days is not really enough to discuss everything about RA 9184. As you go back to your respective offices, we hope that you may share to your co-workers and apply what you have learned from this training to help your office manage your procurement activities. This time, mas well-versed na po tayo ngayon sa rules. Alright, to our Facebook viewers and YouTube stream na sumubaybay from the first day until the last day of our batch 3. Maraming salamat po. We would like to acknowledge also the efforts of our GPPB recognized trainers, to Attorney Clemente, Ma'am Grace Ortiz, Undersecretary Chan, Director De Vera, and to Attorney Isa, who have shared not just their knowledge but also the experiences in government procurement. Maraming salamat po for being our partners in capacitating our procurement practitioners.